Good evening, everybody. Welcome to the following program. I am your host, Joe Nierman, a.k.a. Good Lawgic. Tonight, I have a special edition of Good Lawgic. I got a phone call from Nate the lawyer, who was touching base with me because I hadn't spoken to him since New Year's. And we had this little chat, and somehow it got into a conversation about the Pretti shooting. And I'm sure you're all familiar with the Pretti shooting. I'm not going to give you all about this. Pretti is a reference to the guy who was shot on Saturday morning, and in Minneapolis. And I think you all should know about that. If not, I can't really help you out, although you'll probably see a lot of video on this. And his position was very different from the position that I heard from Andrew Branca. Andrew Branca, as you know, calls this a lawful shoot. And Nate thinks that it's not a lawful shoot, that there's proper charges for murder that can be brought here. So I said to Nate, can you come join me tonight? And he said, sure, I'll join you. And I said to Nate, is it okay if I ask Andrew if he joins us? And he's like, sure, that's totally fine. So I reached out to Andrew and he's like, sure, I'll join you too. So what we have here is now two friends of mine, people I consider people I've met in real life, both of these fine gentlemen. They're both smart men, great content creators, and phenomenal attorneys. And they're holding completely opposite positions as to with respect to this shoot. And frankly, I'm not a criminal defense expert. And if I hear a legal argument, I say, okay, that makes sense to me. And then I'll hear a different argument. I'll be like, okay, that might make sense to me also. And that's why we're basically having this little debate here. And it's my privilege and pleasure to bring these two fine guys to you, these two fine attorneys to you, and hopefully we actually got someone here tonight. I'm going to be doing very little talking. I'm going to be playing more of a moderator type of role, and we'll let them go. And I think that we're going to start. I think before we started backstage, let's start with this, gentlemen. If you want to just introduce yourself to the audience, we'll start with you, Andrew, because you're upper right.
Sure, Attorney Andrew Branca. My day job is criminal defense, use of force law, self-defense, how to defend yourself, your family, and your property, consulting practice, consulting to other attorneys representing their clients in those kinds of cases. And then my second job is legal and political commentary on YouTube at The Branca Show.
Yes, indeed. In fact, if you send me a link, I'll make sure to link both of you guys. And Nate the lawyer, if you can just tell everyone in case there's anyone watching this who doesn't know who you are.
Hey, my name is Nate. I have 10 years of law enforcement experience. I've also trained at the police academy, and I've trained officers in both use of force, and I was also an assistant district attorney and prosecuted some officers in these issues. I also have been a defense attorney and have represented both officers and civilians. As of right now, I'm a YouTube commentator, and I do civil litigation, generally in mass torts and things of that nature. So I have my own firm, I'm happy to be here, and I honestly love the law. And I was talking about the law because me and Joe speak for hours sometimes about the law back in the day.
We'll fight it out off camera and on. But it's always with the objective of figuring out what real truth is. Yes, I want to give a heads up here because I don't want anyone to be upset with me with respect to super chats. I'm going to pull this up here because it's a significant super chat that came in early from Jade Schwalbach saying, Joe, thank you for giving us the black and white breakdown of the pretty good shoots. Love DeBranca and Nate the boss. Make this a regular show at least once a month. If I could book these guys coming once a month, I would do it in a snap like that. Are you kidding me? It's much easier. But I do want to be clear before I go any further that I'm not going to be reacting to super chats. I don't want people to be sending me super chats and expect me to react to them as quickly as I normally would, because I don't want to disrupt the flow of the back and forth. I will get to all of them. I will, and I'll bring them up. And I'll bring them up on screen, but I'm not going to be reading them the way I normally would, because I just can't. I don't want to disrupt the flow. I think that would ruin the show for everyone. I don't think that's the right way to handle this. So I just want to give you that heads up. I appreciate your super chats, and I will go through them later on. But I just wanted you, and the $5 ones I may just bring up and not come back to be frank with you. But if the larger ones, I'll definitely review later on, so that this way I have a chance to digest it when there is a break. Because I really want to hear what they have to say. It's a very interesting conversation to me. So I don't want any of my viewers to feel as if I'm giving a short shrift. So that's why I'm giving that heads up in advance. Anyway. So I
mean, just to be clear, Joe. So I really only have like 5 minutes to say, and then Nate can,
yeah, we're going to start with you, Andrew.
Yeah, but there should be plenty of opportunity during the give and take to read super chats if you want to. Yeah, it'll.
Okay. All right.
The one thing I have to say though is this the way we're doing this now isn't working on my end. So what I'm going to do is I'm going to trigger the stream to your audience option. And I don't know what that'll do, but if you're watching my channel, The Branca Show on YouTube, it's going to end. This show is going to end for you. It just didn't work out. But I'm going to try to trigger a second show. So you might look for that when I press this blue button. So let me hit this blue button and see what happens.
I want to stream to your audience. Yeah, I've been having problems with that too. I don't know.
No, he set up his own stream instead of doing streams to your audience. He set up his own stream, and he started beforehand. So that's where his viewers were. Right.
That's where they are.
That's where they are. Right. But
so I have to fill in just a little bit of information here, apparently, and just like the title and the
do what you got. Do what you got to do.
So
take a minute there.
Let me just I'll go because what I'll say is that me and Andrew actually agree with a lot of cases together. Ashley Babbitt, we agree with the Renee Good, because I've seen Joe's coverage and Andrew's coverage, and I believe that was a justified shooting. So, and in this particular case, I do agree. I don't want to make it seem like I disagree with everything, but there are some things that I fundamentally disagree with the analysis, and we'll get into that also. So but I think in whole, when it comes to, let's say, Renee Good, I think and I think I was attacked pretty viciously, where it's just something which is wild happened. So I made my video, got 1 million views, and people started rating. They started calling the advertisers and was trying to get my advertisers to cancel me. Like, because they said the video was so convincing that it was just, so they were trying to get, but those idiots forgot that when you send emails and call and text message the advertisers, they aggregate all that information because, hey, these are real phone numbers, these are real emails, and they can sell that to the market. So it became actually a good thing, and they re-up. But it's interesting because I never thought that you would get so much hate for just an opinion on a case, and it seemed like the fact that it was well thought out made me the enemy of the state. So it was freaking insane.
Well, that's the way when you're dealing with folks who have a predisposed narrative, and that they're like, this is the truth that we want. So they don't want to engage in actual dialogue, and they're certainly going to resent people who are going to present a compelling case that they're wrong. That's where cognitive dissonance comes in and says, no, you're just wrong because she should still be alive, and he could have sidestepped the car. So they don't look at what the law is. They're looking for someone who's going to give them that confirmation, and it's confirmation bias, where they're basically saying, if someone's telling me what I want to hear, then great, and if not, then they must be wrong.
It's funny. I was debating Pisco on the Renee Good case, and we went to the case law, and the case law was, there was a case which the Supreme Court said continuous shots, in short bursts, no breaks, and it was 15 shots within 10 seconds. And in the Renee Good case, it was 4 shots within under a second. And he's like, we can distinguish first shot, second shot, third shot. I said, no, the Supreme Court clearly is going to consider that, or any court going to consider that one use of force, not 4 separate instances of use of force. It says that in the case, but it's like he wanted to believe the officer could stop and reassess every 2.2 seconds between shots being fired while being hit by the car. I'm like, that's impossible. That just doesn't make any sense. But
right.
Sometimes you just can't. When somebody already has the truth, you can't tell them the truth because they already know it.
Yeah. I'm wondering how Andrew is doing with respect to his restream. How's that coming for you?
I think it's working. My audience, well, I think I just dumped them, but my audience will have to go to my YouTube page, and there should be a new broadcast happening right now. But I'm up, and no, it's okay. We'll just go ahead and be. They've actually heard already everything I'm going to have to say here, because of course we've all been covering this endlessly.
And I think you want me to share your screen that you have there. Is that what you want me to do, Andrew?
Yeah, if we could. So I have two videos. The first one's less than a minute. The second one's about a minute and a half. They're the same videos, but the second one I slowed down and I put little numbers in the top. And each change in the number, I'll just give people a heads up of my interpretation of what's about to happen. So that kind of encapsulates step by step how I see this having gone down. But the first video here is just straight through. So let me hit play.
What the fuck is wrong with you?
Oh, I should mention, at one point in the middle, the resolution changes because I got a better resolution video for that portion, so I stuck it in.
I did the same thing.
In full disclosure. So you'll see the image gets a lot clearer.
The fuck, people! The fuck is wrong with you? Honestly!
Okay, we don't have to listen to her. That's really the end of the action right there. And then I have this video, which is a slowed down version of it. And let's see, did it pop up? Okay, you see there's a little number there at the top. So I have little pauses along the way. So what I see here is this is Alex Pretti. He's standing in the middle of the street. He's appears to be cooperating with some others and just attempting to disrupt what's happening here. This is not like a protest where they're out in front of a building holding signs and stuff. The Customs Border Patrol people went to this particular address to arrest a particular person, and they're following CBP to disrupt that operation, is my understanding. So it's him, it's a woman in a white coat, and a woman in a brown coat are the three people on his side of this thing. So we'll see a car go past Alex Pretti, and when the car goes past him, he starts advancing pretty aggressively towards the CBP people, yelling at them, yelling questions at them, filming them. It's just what they do. And then we'll see the camera tilts down to the snow. And when it comes back up, of course, the scene has changed a little bit. Alex Pretti will have his arm around the woman in the brown jacket, kind of moving her towards the sidewalk. So that's what we should see. Let me move this over here in this little piece before the number changes to the number 2. Oh, and I slowed it down so we can watch it more leisurely. I muted that because the woman's just cursing a lot. We don't need... Okay, so that's that first segment. Now, in the second segment, we have the first, I just call him CBPA, the first Customs and Border Patrol officer here. It appears to be ordering Miss Whitejacket off the street onto the sidewalk. Obviously, they're running a law enforcement operation here, so they're trying to maintain scene security, keep people at a certain distance. A good way to keep people at a distance is to have kind of a bright line test for them, right? Not move back a couple feet, but get off the street, get onto the sidewalk. That's very clear for everybody. She doesn't want to do that. She doesn't comply. So the CBP officer shoves her off the street onto the sidewalk. That's what happens here. All right, so that shove happens, and then Alex Pretti steps in and impedes the CBP officer. He actually lays hands on the CBP officer. I have a different angle on that here that makes it pretty clear that's what happens. So I think it's pretty incontestable that Alex Pretti is making contact with that border. Now, he may think he's protecting the woman or whatever the case may be. I'm not suggesting it's necessarily with malice, but he's making contact to impede that officer's ability to interact with Miss Whitejacket. Let's see, that gets us to, I should mention, so under federal statute 18 USC 111, if you impede a federal law enforcement officer in the course of their duties and you do it with contact, that's an 8-year federal felony. So this is a forcible felony that has now been committed against this CBP officer. So that's obviously an arrestable offense. Even if there was no contact, it would still be a Class A misdemeanor. Still in the presence of the officers, they're allowed to make an arrest there. So this CBP officer says, well, I'm escalating up the use of force continuum. I gave her a verbal command. She wouldn't listen. I shoved her, and I'm still getting resistance from people with her. So now I'm going to escalate up to a chemical irritant, which is here. The OC comes out, sprays Alex. Now remember, he's subject to arrest now. So these other CBP officers start coming in, and everyone's going to get in. White coat, the woman in the white coat tries to get up out of the snow. Brown jacket is helping her. The other CBP officers are coming up, and you can hear them shouting, get back to these two. More pepper spray is deployed here. You hear it?
I don't hear anything.
I don't hear it, but
you can't hear it?
No.
Oh my gosh. I forgot to switch the video. Hold on.
But we I've seen the video, so
that's okay. But everyone, I want the audience to see.
Right.
So.
It only takes a few seconds. So here's the push. Here's Alex Pretti intervening. Here's the pepper spray, and that catches up back up to speed.
Okay.
And we already covered white coat trying to get back up. More pepper spray. That must be nice. All right. So at this point, the officers are putting hands on Alex Pretti. They're looking to arrest him. He's trying to help the woman in the white. Pretti. Sorry, Pretti is a dish. Yeah. Pretti. The officers are trying. They have hands on Pretti. Pretti's trying to pull the woman up. So the officers are pulling him up. They're trying to secure his arrest. And at this point, they pull him off the woman. They get him on his knees on the ground. He immediately pops back up. And then they get him back on the ground again. And we see at least 3 officers now are trying to gain control of Alex Pretti as he continues to resist lawful arrest.
The fuck, people? The fuck is wrong with you?
Okay, so there's 2 important people here now. There's the guy in the middle crouching over. I call him Gray Jacket. And there's the guy in the green here, whose back at the moment is to Alex Pretti. He's still dealing with White Jacket. These 2 people are important because Gray Jacket is going to be the guy who secures the gun off of Alex Pretti. And Green Jacket's going to be the guy who pulls the service revolver, the first guy we see in the video. He's going to, we'll see as Gray Jacket is working on getting the gun, searching Pretti. Green shirt is going to turn around, so he's facing Alex Pretti. Right now, he's facing the opposite direction. At this point now, Gray Jacket observes Pretti's pistol. He sees the pistol at the 4 o'clock position. He decides he's going to secure that. He grabs it, and there's a lot of shouts of gun, gun, gun. Now, it sounds weird because they don't say it that slowly. They say it like gun, 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 gun. It sounds almost like a machine gun, but that's what they're saying. And the moment that shout goes out, the guy in the green shirt puts his hand on his service pistol and starts to present that service pistol. So now the guy in the gray jacket has got Alex Pretti's pistol, and he's going to distance himself from the scene of the fight because that's what you want to do. You want to get the uncontrolled gun away from the scene of the fight. The guy in the green jacket, in the green shirt, has drawn his service pistol. He's presented it. He's now pointing it, presumably, at Alex Pretti. The next step is as Gray Jacket moves away from this fight with Alex Pretti's gun in his hand, we hear a gunshot. Now, I don't know to this moment if we know where that gunshot actually came from. It might have come from Gray Jacket. It might have been an accidental discharge. It might have been. I just don't think that we know. I don't think it matters for legal analysis purposes. But that's when we hear the first shot. And when we hear that first shot, all the officers start to jump away from Alex Pretti because that's what you do. Now it's a gunfight. You want to distance yourself. You want to give yourself room to draw your own pistol and neutralize the threat and so forth. That's the first shot. Now, we don't really know, again, where it comes from, but within a second of that first shot, then we get 3 more shots fired, presumably by officers. And those shots come in pretty quick succession. During these shots, the period these 3 shots are being fired, we can see Alex Pretti has a black object in his hands. This is a freeze frame from that 3-shot period. So he's got a black object. I'm not saying it's a weapon, but it could be a cell phone. Some people say it's a magazine, one of his spare magazines. I don't know what it is, but it's an object in his hand, and he carries it all the way to the ground with him. So he still has it when he hits the ground. And I would suggest that given the circumstances up to this point, the cries of gun, 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 an unanticipated gunshot, and then they see this guy, his hand coming from the 4 o'clock position where his holster was. Because you have to remember, not every officer here knows all the things every other officer does, right? Not every officer here will necessarily know that Gray Jacket has secured the pistol. When Gray Jacket turns away, he very quickly turns his back on a bunch of the officers, right? They may not know he's got Alex Pretti's pistol in his hand. So we have those 3 shots. We know that Alex Pretti has a black object in his hand. It's coming from where his gun was holstered. Some of those cops are going to see that black object immediately after hearing gun, 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 and hearing a gunshot. And then within seconds of those 3 shots that come out, we hear another shot, and then we hear a series of 5 shots, and that's when we get to the end of all this. That's the 3. So that's the 10 shots in total. Now, the legal standard for whether or not this use of force was justified is, did the officers who fired their shots, did they have a reasonable, not a correct necessarily, we don't require perfection in the use of defensive force, but a reasonable, based on the application of their powers of reason to the evidence they're seeing, the things they're hearing, did they have a reasonable perception that Alex Pretti was presenting as an imminent unlawful threat of deadly force harm? If the answer to that is yes, well, even more important than that, the prosecution would have to disprove that proposition beyond any reasonable doubt. And what that effectively means is that if you can look at this video or the collection of evidence, and there is a narrative consistent with the evidence, that's consistent with reason, then by definition, there's a reasonable doubt and there cannot be a conviction. As a matter of law, this would be a legally justified shooting. And that's what I got.
Do you have any questions, Nate, about the way he presents it, or at all?
Well, I was going to just go over my rebuttal.
Okay, before you do that, just so I can crystallize Andrew's position here. So there are a few things that I heard you say in there that some would say, I want to play devil's advocate for a moment. Some would say that for example, I didn't hear the gun, gun, gun. I know people say that they've heard it multiple times. When in the recording you just gave us, I don't hear them screaming it. But I don't know.
But I'm going to concede that because I did hear it when I did the analysis. So I'll concede that point.
And I assume you agree. I think all of us would agree that if the Gray Jacket guy, after he took the gun, would scream something out declaring that he's gotten the gun, in that case, this would not be justified because they know he's. Or would you say that since they don't know if he's got another weapon?
Right. Yeah, just him screaming gun, gun, gun. Even if he says I have the gun, he could have another weapon.
Right. So even in that scenario, they would still be justified.
Yeah, they would still be. Yeah, you would. Still,
I mean, just to illustrate, I carry a gun every day. It's not my only weapon.
Yeah.
I have another weapon on my person.
Matter of fact,
at least one.
It makes you think that the person may have more weapons because you found the gun.
Right.
So it tenses you up even more.
Okay. Fair enough.
So first, I want to say that was a fantastic presentation. I really, really appreciate the in-depth part of it. But you've given me you gave me you gave me some law, the 18 USC section 111 you spoke about. But you've not given me any case law to really combat. So what I do in these analysis is that first I start with from my legal analysis, I start with the case law and then work my way back. And I think you've made some critical errors in your analysis. First, where you started your analysis.
Okay.
You started your analysis in the wrong place. And I'll go back to first Graham v. Connor. Graham v. Connor is a Supreme Court case on point. What I'll do is I'll have a PowerPoint presentation now.
Where's the place we should have started?
I'm going to go into it. So,
if you have a screen you want to share, feel free.
I'm going to start sharing my screen now, and we can go into it. Hold on, share screen. There it is. So, if we're doing legal analysis, we have to start with this case, Graham v. Connor. I don't care what law enforcement agency you're at. If you look in Alaska, Georgia, California, wherever, they use the Graham v. Connor standard. Matter of fact, in looking up this case, the Department of Homeland Security and ICE actually cite this case in their use of force policy as the standard they use. So this is a standard that is being used. And I think I even have a slide. Do I have a slide? Yeah, with it. Yeah, here's that policy as a link. And they actually cite Graham v. Connor and Tennessee v. Gardner. So this is a standard that is being used in this particular case. Federal law enforcement, everyone, this is the case. So whenever you're doing a legal analysis, this is where you have to start. Now, Graham v. Connor stands for the proposition of the objectively reasonable standard. An objective standard used to judge an officer's actions. Under this standard, a particular application of force must be judged through a perspective of a reasonable officer facing the same set of circumstances without the benefit of 20/20 hindsight, and be based on a totality of facts that are known to that officer at the time the force was used. Now that's Graham. And then Graham, the court then gives you three factors that you want to consider. These are not exhaustive factors. These are three factors the court says you start with, but then you move forward. For instance, the nature of the 911 call, whether the person was resisting arrest, and whether the person was a serious threat to the community or the officers. And then you would determine if based on these factors and the Graham standard, would this be objectively reasonable? Now, it's a difference between being subjectively reasonable with the officer himself, how he feels. We essentially remove that officer and put a fictitious officer and says this fictitious officer is objectively reasonable, and how would another officer being that would actually do it. So
Nate,
now,
you very kindly didn't interrupt me, and I don't mean to interrupt you, except I think it might change how you approach your narrative if I ask this question, which is why I ask it. Are we talking about the criminal liability of the officers who shot, or the civil liability of the department?
No, I'm talking about the criminal liability of the officers and the civil liability. So I'm focusing on the criminal liability because that's what we were talking about.
Okay. Well, Graham v. Connor is a civil case. It's not a criminal case.
Yes, it's a civil case that
the officer wasn't part of the case at the Supreme Court. He'd been dismissed for qualified immunity.
But let me again.
That's why I asked. I mean, if we want to talk about civil liability, I'm happy to do that.
Just to let you know. Well, again, this is maybe an ignorance to Graham v. Connor, but if you just look at the policy from the use of force from the Department of Homeland Security, it says it right here.
Right, they don't want to get sued.
The officers are going to be sued by the Graham standard. This is what they say. In determining the appropriate and particular use of force, the department is guided by the constitutional law interpreted by the Supreme Court. The Fourth Amendment applies the constitutional baseline for permissible use of force by Leos. This is not about being sued. This is about if you fail Graham, you will go to jail. And down here, Graham v. Connor. This is black letter law. Now, I'm kind of surprised, but this is black letter law. You can look at Alaska, look at wherever. This is black letter law. But now, this case,
if I could just ask you a question, because he piqued my curiosity here. Sure. Graham v. Connor sounds like a title of a case that's a civil case, not a criminal case.
It's a
civil case.
So now if it's a civil case, and that's the yardstick that's used to determine whether there's civil liability. That does not necessarily create criminal liability. And the question that if I'm coming from Andrew's perspective here, the first question I would ask you is, just because DHS wants its LEOs, wants its LEOs to abide by, to conform with the civil standard, that does not mean that there would be a criminal liability now for this guy, unless you're saying because he's breaching DHS standards, so that now makes it something that's criminal. You see what I'm saying?
So this, again, this is an ignorance for people who are not in the field, who do not do the work.
That's why I'm asking.
That's what I'm trying to explain it. So Graham is a civil case. And the holding in Graham was about the use of force. And it was specifically about, under the Fourth Amendment, what's reasonable in terms of a search. Now, what happened in Graham, just so everybody understands what happened in Graham. An officer was standing outside, was parked across the street from like a gas station. A car comes up to the gas station and the gentleman runs out. He runs into the gas station and then runs back out, jumps in the car, and the car flies down the street. The officer then follows that car down the street, eventually pulls it over. They get into a fight. The guy's arm is broken. The cop obviously thought that he had just observed the robbery. That's why he followed the car. When he follows the car and actually pulls the car over, come to find out the guy was having a some diabetic issue. So he was looking for orange juice, and when he went to the store, they didn't have the orange juice, so they were going to another store. It was a total mistake. But Graham and his family sued. His family sued, saying, "Well, hold on, this does not, this is wrong, And the Supreme Court then said, "Well, we did an analysis based on the Fourth Amendment seizure, and what is lawful, and what the Constitution protects for the Fourth Amendment seizure." And they said, for a Fourth Amendment seizure in this particular context to be reasonable, then officers must be objectively reasonable in applying this standard. So that's where the Graham standard comes from. Now, if you look at any case that talks about use of force in criminal context, for instance, Derek Chauvin's case, Ahmaud Arbery's case, any case where you see a police officer, they mention Graham. And if you want to put, and I can pull up all those cases, and I can pull up exactly where they say you have to meet the Graham standard to avoid criminal liability, because if you violate Graham, the court says you have now committed an unreasonable seizure. An unreasonable seizure in that sort of gives you both civil liability, but then an unreasonable seizure based on unreasonable use of force gets you the criminal liability. So if you satisfy Graham, then you don't have a problem. And in this particular case, since we're talking about a federal agent and Minnesota law, let's say the state charges the federal agent then gets, by right, can say, we're going to remove it to federal court. And if they remove it to federal court, the court's analysis is Graham v. Connor. If the officer actually was objectively reasonable under Graham, and if that's true, then the state loses the ability to prosecute the officer. But this is black letter law, so it's if you're telling me, trust me, they just ask any law enforcement officer.
You had me at, this is the case that's used in criminal context as well. I just wanted to establish whether or not that's, now that once you tell me that that's how it's been used, so I'm like, okay, fine. So let's work in the Graham v. Connor world.
I have to tell you, and I don't think it matters.
Let me finish this point.
Okay.
If you look at the DOJ's website too, there's another civil case that the DOJ uses, which is Tennessee v. Gardner. It's against the fleeing felon rule. You can't shoot a fleeing felon in the back because it would be illegal. You would be committing a crime. But that was a civil case. But now that has transferred into the criminal context with any law enforcement officer who shoots a fleeing felon in the back who's not a serious threat to someone will be violating Graham and then be criminally charged. But go ahead, Andrew. I'm sorry. I just wanted to make sure.
I was just going to say I've covered trials, prosecutions of police officers where the judge did not allow Graham or Tennessee versus Garner to be argued because it was a criminal prosecution and those are civil cases. Now, I don't think that changes the analysis here. So I only mention that for your information.
All right,
whatever Graham says,
I would like to see.
Let's apply Graham here. Let's assume for argument's sake we're applying.
Well, I would say, don't trust me. You can ask any law enforcement professional who's actually in the field, and they will tell you Graham v. Condorcet.
Because their department trains them because they don't want to get sued.
Again, they will tell you Graham v. Condorcet.
Okay. Well, fair enough. Let's presume that's the case and apply it here.
So that's the case. That's why that's DHS policy. Now, so what Graham says is that you have to look at the totality of the circumstances. Now, another thing is that, so what you have done is you looked at just the part where the officer shooting occurred, right? You said, okay, we're going to look at the officer shooting, the time the force was used. But the Supreme Court expressly rejected exactly the way that you just reviewed this case. The Supreme Court expressly rejected it in a recent case, actually, in a 9-0 decision. It's called Barnes v. Felix. And in that case, the Supreme Court said, well, hold on. The ruling, the Fifth Circuit had said, we're only going to look at the time force was used. In that case, a cop, a guy was pulled over, guy's going to pull off, the cop jumps on the hood, the guy starts driving off, and the cop shoots the guy. Now, the cop was like, he was scared for his life when he's on top of the hood and the guy starts driving. But the family was like, well, hold on. You put yourself in that situation by jumping on the hood. You weren't in danger until you put yourself in danger. So then the Supreme Court, the Fifth Circuit at that time said, well, you only have to judge it when the force was used. So if he had a fear for his life when he was on that hood with that gun, then he was that's a good shoot. But the Supreme Court overruled that and said, no, you have to look at the totality of the circumstances from beginning to end. You can't just pick that particular moment and ask. You have to find out what happened before. And Andrew, unfortunately, he didn't look at the entire event to see what happened before and what happens after. He actually violated the Supreme Court precedent by only looking at that moment. So what I'm going to do now is that we're going to look at the entire event as the Supreme Court demands we do to see if this officer was justified in using this type of force.
And I think that's fine, Nate. But to be fair to Andrew, he did break down different moments. The first 5 moments were before there were any with the white coat woman and the interaction there, and when Pretti was first putting his hands on them. He did break that down. So I don't think it's fair to break down that Andrew didn't present anything as to what was happening the setup of this.
I'm saying you got the whole situation. Now, let me.
I guess what I would ask, Nate, is I'm familiar with Barnes v. Felix, where the cop jumped on the hood of the car, and that's why the cop ended up compelled to shoot because he put himself in that position of peril. Where's the jump on the hood of the car moment here?
Who's saying this is jump on the
No, you're saying Barnes v. Felix is relevant here. So the key issue of Barnes v. Felix was the cop jumped on the hood of the car. Where's the equivalent of that here?
Well, maybe he'll show us that now. Let's let him show his video.
Hold on. There's an ignorance about what I'm using Barnes v. Felix. So
I'm ignorant all night.
No, I'm just saying there's an ignorance and maybe you're understanding what Barnes v. Felix is saying. Barnes v. Felix does not stand for the proposition of cops jumping on cars. Barnes v. Felix stands for this direct proposition that you must look at the totality of the circumstances and not just the moment before the shots.
But the totality of the circumstances has to have a scope, right? It's not like what happened last year. It has to be material.
Well, that's the holding of Barnes v. Felix, not whether the car jumped on the hood. That's just,
But that is the material fact that they were addressing.
We're talking about the holding of the case. And the material fact wasn't not about last year. It was about the particular event.
Nate, why don't we do this? Nate, why don't you just tell us which moments you
show us what you want to show us.
I am, but what you're saying about last year and all that stuff, it's like you don't know what
we're good. Let's move along.
Gotta get there. All right, so let's talk about the entire event. So what I've done is that I'm using this video that you're going to see some concurrent video. I'm
going to make us smaller so that people can see this bigger. So this way, that should be better.
Better?
I think, we're good now. Go.
All right. So I'm going to show this event. Now, this is the earliest video that we have about him. So this is the video that Branca showed earlier. So now at this point, we have the 2 women in the street and we have the guy filming. Now, 7th, 9th, 8th Circuit all say what they're doing here is legal. You can legally yell at an officer, you can legally stand in the street, and you can legally film an officer. All of those are constitutionally protected rights. But what you cannot do is you cannot block the officer, you cannot stand in front of the officer, but you can do civil disobedience. Now, I actually have the case that shows that from the 8th Circuit. Presence, screaming, because blowing a whistle and yelling at the officer is actually a constitutionally protected right. And there's a case from the Supreme Court that's on point with that. City of Houston versus, let me see, I had it here.
Can I concede points? Would that save time?
Sure, if you want to concede that.
Yeah, I'll concede that you can yell at an officer, you can, blow whistles. What was the other thing you said?
Film officer.
He said stand in the street also.
And stand in the middle of the street.
Yeah, I'm not sure about standing in the street. You can stand in the street to protest, but I'm not sure these people were protesting. They're actually impeding. I think that's different. But let's.
So where are they impeding?
But I don't want to force you to cite case after case if we don't have a disagreement. So.
All right, well, I'm citing case after case because I want to use the Supreme Court precedent to make sure it's all.
Oh, you can do it if you want to. I'm not trying to stop you.
Yeah, but so I don't want to just shoot off the hip because I want people to understand that I'm pulling the legal paces here. So in this particular moment, the officers now are being confronted by these two women, but no crime is being committed. Now, I would say this, no federal crime, because these are federal officers, and the only thing they can do is actually arrest you for violating federal law, unless you're in like a state like New York, which endows upon federal officers local peace officer status to allow them to arrest for local violations. But in Minnesota, they don't do that. So these officers can only arrest for federal violations. So right now, if you like, in other words, those officers.
Did anyone ever try to arrest these women?
Where I'm assuming they did. Because
no, they
all right, well, hold on. Well, let me finish what I'm.
Okay.
I'm going
all right.
So right now, these women are just two people. Now, the difference between an officer using force and a civilian using force is that an officer is authorized to use force to either detain you or arrest you. Now, if an officer uses force and is not legally authorized, that's just assault. That's what we call assault. Any law enforcement officer will tell you, you can't just go up to somebody and punch them in the face without legal justification. Right. Now, if you commit an assault, because an arrest sometimes is an assault, but what allows the officer not to have criminal liability is because it's justified. Correct. And it's justified by the Fourth Amendment.
I agree.
So now we're going to play it. And we're going to see if the officer is going to commit an assault.
Go.
Now this camera is going to pan away, and you're going to hear him scream something. Now, he says, do not push them into the street. So if these women are now being pushed by the officer, that would be an assault. But we have the angle to see if the officers are actually pushing the women. Now, remember what I said. The officers, if they put their hands on these women, have to justify that assault. Either they're arresting them, but Andrew has just.
But isn't it obvious that the justification is scene security? They're creating distance from the active law enforcement operation?
Well, let's go back to the other video. Because in the other video, the active law enforcement operation is the cop about to get into the car to go, and you actually see the brake lights come on. So that is not an active law enforcement. They are about to leave, and the cop actually gets back out the car and then confronts the women. So now let me go back, since I've answered that question. Let me go back to this one. So here we're going to see the officer now. With the angle that we saw with the officer, where the guy said, you push the woman, we're going to see what the officer actually does. And you'll see it right here in the corner. I'm going to have to blow it up, but right here in the corner, you get to see what the officer does with these women. He pushes this woman, and as you can see, she turns around. So I'm going to run it back, because in 4 seconds, and so I'm going to run it back so you can see this right here. It's going to be right here on this side, on the left side. Oops, here we go. And you see the officer push that woman. So he pushes her. That's an assault. So that
it's not.
Hold on.
It's not an assault. Andrew, it's not an assault because it's legally justified. They're entitled to protect scene security.
Andrew, I let you say your piece, and I know I'm destroying you.
I mean, you're talking a lot, Nate, but okay, go ahead.
Finish my point. Because
okay.
I know this is embarrassing. Maybe
I know. I'm humiliated, Nate.
I know, because you wanted to let me finish my points. I sat here and let you say.
Okay.
You know what? Here, I'll let you finish. Say what you want to say.
A police in an active law enforcement operation are allowed to have scene security, just like at a crime scene. They're allowed to keep people at a reasonable distance. This is just across the street. If people are closing that proximity, the police are allowed to ask them to leave, to make distance, to order them to make distance, and if they don't obey that, to push them back to maintain distance. Police do this every day, thousands of times all around the country. It's not a criminal assault.
Now, Andrew, you're wrong. This is a criminal assault. What you're talking is BS because you don't know what you're talking about. So now let me finish what I'm saying. This is an assault. And because when you are pushed violently like this, the police now have to justify this assault. Is this assault justified? Now, let's continue. Is there another assault? Well, yes, he pushes the woman again. That's the second assault that now has to be justified. Who says it has to be justified? The law says it has to be justified. You have two assaults that have to be justified. Now, you go to the third assault. Here is the third assault. That's a third assault. Now, if I want to make it very clear, in each one of these assaults, they are not fighting the officer. They didn't hit the officer. And Andrew said this is for scene compliance. But let's see where the original scene was. The original scene is the officer's getting into a car about to drive away. So scene compliance, they're about to leave and they don't leave. Instead, what do? This officer gets out the car and starts pushing these women because he's assaulting them. So now we have these three assaults. And the reason why you start at the beginning is because you see how the Leos are assaulting these women. So now let me continue. So we have these assaults and we have this officer now, which I think one thing people don't really realize in the federal law, you don't have a right to resist arrest, even an unlawful arrest. If the arrest is unlawful, you have to comply. But you do have the right to self-defense for unreasonable force. So if an officer is using unreasonable force against you, you do have a self-defense right, a common law self-defense right. And the policy for that is because you just don't want officers being able to beat people or kill people indiscriminately. So you have a right to self-defense against unlawful force. Now, in this particular case, this officer has not been justified in any of these pushes, in any of these use of force. Matter of fact, the person's on the other side of the street and the officer's alone. The officer doesn't have anybody else with them and they're still pushing. Then, because this is now unreasonable use of force, Petty then steps in to try to block the officer from continuing to use unreasonable force against the civilian. Again, if some people may say that police are allowed to indiscriminately push you in the middle of the street, even when you're across the street and not even in the action, then unfortunately you're wrong. That's an assault. So let's continue to look at it. So now the officer is spraying pepper spray. So now the officer has moved up what's called the use of force continuum. The use of force continuum starts with officer's presence. Then you have what they call soft hands. Then you have hard hands where you're doing hammer locks and things of that nature. And then you have your spray, OC spray. So now he's taking a full can of OC spray. What does that do? Well, someone like me who's an OC trainer, who should train in OC and trained in self-defense and also trained in use of force, what the OC does, now you can't see, now your skin is burning, now your eyes are burning, now it's hard to breathe. So what that does, it makes it harder for the person to comply because you're trying to get compliance by putting their hands behind their back. But usually the person is trying to rub the stuff off their face so they can breathe, so they can see. So what sometimes looks like non-compliance to someone who doesn't know what they're looking at, an officer would understand that, yes, if you hit somebody with OC spray, it's going to seem like non-compliance because they're in this particular situation. So now he's being sprayed with a can of OC spray. Now, obviously, there is no resistance here. So with no resistance, again, you're using a very high level of force for people who are not actively resisting. And the department policy says if you don't have any active resistance, you shouldn't even be using OC spray, but because violating policy doesn't mean this is unconstitutional. So I want to make sure. Violating policy does not mean it's unconstitutional. It is a factor to consider to determine whether this is being reasonable or not. So let's play it. So up to this point, what we've seen is essentially 5 assaults and an escalation by the officer. Now, this officer has escalated to the point where now there is no crime that's been committed, and who's being arrested? Because if you could say, well, they're being detained, then you would be able to use force. If you're saying that they're being arrested, then you're being able to use force. But no one here has been arrested. No one here is being detained. So we continue to move on. Let me go back to now this angle. So when we talk about this angle, I'm going to move toward the shooting. So here we go. They're wrestling in front of the white car, the blessed white car. We have the secondary angle. The officer is now pulling Pretti down, and Pretti is now on the floor. Now, at this point in time, the crime that some people say Pretti has made was the 18 USC section 111. 111. But now, I would even go as far to say you could even maybe make that argument. But the problem is that this is the officer who escalated to this point, has created this entire situation. They unjustifiably started pushing and assaulting civilians all the way to the point of unjustifiably using pepper spray to spray them in the face. Now, he is now we also have to, and this is with taking the totality of the circumstances into account. This is why it's so important, because Pretti at this time has a half a can full of mace in his face. Now, I don't know if anybody in the comment section has ever had mace in their face, but this mace, what it does, it forces you can't do it. It's even hard to breathe with mace in your face. So what can look like passive, what can look like resistance, can also be someone struggling to breathe.
Nate, I've also, you've been talking for like 10 minutes. Can I say something?
Of course, yes.
Okay. I've also been a certified mace instructor, an OC pepper spray instructor. I think you'd agree that it doesn't have the same effect on everybody. Some people have a great effect and some people have relatively little effect. Is that not your experience?
Yes.
So an officer can't count on the OC spray making someone unable to resist or fight. Is that not true?
That's true. Yes, you cannot count on it. That's
okay.
Correct.
All right. Okay. Go ahead.
That is 1,000% correct. But it's like saying 9 out of 10. It works on 9 out of 10 people, but we're going to pretend that it's only for the 10 people that it doesn't work on. So what happens is the policy is generally built for the majority of people or the majority of use. Now, sometimes, and I've seen it happen where somebody has sprayed somebody with a pepper spray and they wipe it off their face and lick their hand. Like they love the pepper spray. But again, we're not talking about.
But you never know. If you're the cop, you don't know. You don't know, right?
We're talking about what's being reasonable. It doesn't have to be perfect because that's your thing, reasonable. So if you're talking,
is that my thing or is that Graham and Connor?
That's your thing. You just said reasonable, but now what you're doing is you're taking the unreasonable position because you're losing the point.
It's reasonable to know it doesn't work on everybody.
Nate, if I could just interject for a second. Mm-hmm. I think what Andrew is saying here is that because of the fact that there's a noticeable percentage of the population that remain unaffected by pepper spray, that it's not something that even any reasonable police officer would say, I have to account for that noticeable percentage when I'm dealing with police
force. You are trained to account for that. You are trained to.
That's what a reasonable officer would do, even though it's not the most common thing to happen.
No, it is the most common thing to happen.
No, I'm agreeing that
you're taking what you're doing. You're taking Andrew's position. Yes, I am. You just said it.
I'm saying, despite the fact that it might be, let's say, 10%, 20% of people that mace doesn't, that it's ineffective, that all reasonable officers, because of that 10 to 20%, that any reasonable officer would say, hey, I know 10 to 20% of the time this isn't going to do anything, and they too would, and they would all act with the assumption that it's not doing anything out of concern for that 10 to 20%. So now you would have all officers would be accounting for that, and that would be the reasonable officer standard. Do you see what I'm saying?
All right. So what I'm saying is that we're talking about percentages and probabilities here. And if you're talking about an 80 to 90% probability, then I think a reasonable officer would suggest that if I'm employing pepper spray, it's going to have this effect. And there's a possibility it may not have this effect, but the more reasonable conclusion is to say is that, yes, the more likely it's going to be for that. I believe that's more reasonable. But if you guys are saying the more reasonable is to take it, that
I don't know what the reasonable. I don't know.
That's what I'm saying.
I can tell you what I'm saying, Nate. Would you like me to say it? What I'm saying is that if there's a 20% chance that I will die because the pepper spray doesn't work, a reasonable officer would be cognizant of that risk of death and conduct himself appropriately.
Well, this is not the risk of death in this situation. I'm saying sometimes when someone is pepper sprayed, and pepper spray we know works 80 to 90% of the time to disable people, just like not tasers don't work 100% of the time. But when you employ one, sometimes it does and sometimes it doesn't.
Right.
What I'm saying is that we're talking about not perfect, not that it know it's going to, but we're talking about what a reasonable officer would consider. And I'm saying a reasonable officer would consider that. Not saying that he's not resisting, but a reasonable officer would say, oh, wow, I just dumped a half can of pepper spray. There may be a reason for the fact that he can't breathe, see, and is burning through the eyes, mouth, and nose. That may be one of the reasonable reasons.
How would an officer know any of that?
Because they just sprayed him with pepper spray.
But how does he know he's getting that reaction from him? How does he know the person he sprayed is disabled in that way? The officer's not feeling those physiological effects.
So what you're doing is you're trying to say it has to work all the time. And again, the standard isn't that.
Is that what I'm saying?
Absolutely no. Yeah, it has to be reasonable. It has to be reasonable. And let's look at the way he reacts to after he's being sprayed. If he's just like, oh, this is nothing, or if he's acting like he's under distress. We can see that right here. Right? He's yeah, he looks like he's definitely not reacting to it. Oh no, it looks like he's reacting to it. Yeah, I the pepper spray may have affected him, but maybe I'm being unreasonable.
Nate, can I ask you? Are you familiar with cases?
Let me finish.
I'm sorry, but are we supposed to have an? If you're just going to talk for 20 minutes at a time, this is pointless.
When you finished your whole thing.
For 5 minutes.
I allowed you to speak. No, well, I watched videos and stuff.
All right.
You continuously cut me off.
Here's the thing. Here's the
going
thing.
Back and forth.
Nate,
I'm almost done, and I just want to finish my point.
Go ahead, Nate. Finish.
Thank you.
Joe, I got maybe 20 more minutes. I had planned on an hour, so
it's about 20. But again, if you want to keep interrupting me, I can't finish. So
you have 20 more minutes to go, Nate.
No,
is that what you're saying?
I'm almost finished now.
All right,
let's go.
But you keep cutting me off. All right. So now we're at the end. Now, at the end, everything Andrew said before this moment, I agree with. I agree with the fact that the shot, who shot. Now my only contention about this particular point in time is that all those other officers who shot after they're hearing the initial shot, whether it was from the officer or from the sidearm taken from the suspect, that it matters because I believe all the officers who shot at that time would be justified after hearing the shot. And I think one critical piece that a lot of people are missing is after the first shot, the suspect actually tries to stand up. So when Andrew showed it, if you listen to the first shot, I'm going to play it, and you'll see when I go step by step, if you go step by step, the first shot happens, and then he actually tries to stand up. And then that's when the other officer starts shooting him. So I think if you hear a gunshot, somebody says gun, 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 and the person tries to stand up, then it's reasonable for those officers to think the gunshot is coming from that person and respond appropriately force. But I believe that shooting in that instance is justified. But I don't believe I believe if you look at the totality of the circumstances, the initial officer has the most criminal liability here because he or she has committed multiple assaults and has cascaded the situation to be in this place. So I think what you can have is essentially a George Floyd moment here, where you can have where if Minnesota tried to charge, they would charge this person with a felony murder. You have the assaults that are occurring on. They assaulted this particular guy, and as a result of these assaults, this led to his death, and that's where you'll get that felony murder issue. And then there's also federal felony murder that you could employ to that one officer. So I believe the shooting from the other officers who heard the gunshot and responded to that threat, I think they're fine. I agree with everything Branca's saying. But to the officer who initiated, who did not have any legal justification for all of those assaults, that's the one who is most critical to me, and I think the one who has the highest legal jeopardy in terms of criminal liability.
Andrew?
Do I understand that your argument is that because the earlier officer engaged in shoving and OC spray, that it was foreseeable from that conduct that Alex Pretti would be shot 10 times by other officers? Because that's what's required for felony murder. It has to be a foreseeable death.
It doesn't have to be.
Of course it does.
It doesn't have to be. It doesn't have to be foreseeable. You can end the commission of an assault, right? And the commission of assault. George Floyd, for instance, he was charged with a simple
First of all, the assault would have to be a felony, right? Felony murder requires a predicate felony.
Let me just.
Where's the predicate felony?
Let me just make it very clear. The felony assault happened first. You had the first assault. Then when you make it to OC,
where's the felony name? Show me one felony assault, Nate. That's all I'm asking.
Yes,
one felony assault. Where is it?
I'm explaining to you the felony assault, but you're trying not to understand.
Okay.
The first assault is a simple assault, right? The second assault, I believe, is a simple assault. But the third assault, when you start using OC spray, that's when you're now moving it up to a felonious assault. Because again, these women were assaulted.
Is pepper spray likely to cause death or serious bodily injury? That's what's required for a felony assault. It
can cause serious physical injury. Yes.
Is pepper spray?
You're an OC spray. You're an OC.
Right. My training is, my knowledge is that pepper spray is a less lethal force. It's not likely to cause death or serious bodily injury.
Correct.
Okay, well, make up your mind, Nate. Which is it?
All right. So let me retort. And my retort is a taser. A taser is also less than legal, and it's also not meant to cause. It's not definitely physical injury. But people have been convicted of murder, and people have been killed by tasers. There was a case in Georgia where the person was tased to death. So what you're saying is
because it wasn't used appropriately.
Exactly.
It was used to torture that person.
And in this particular case, OC spray has to be used appropriately. Number one, since you're an OC spray expert, not an expert, you said you're trained in it. What's the minimum distance that you have for OC spray?
It depends on whether the OC.
No. What is it? It's 2 feet.
Do you want me to answer the question or not?
Answer the question, because I'll pull it up because I have.
There's not one universal OC. There's stream OC, there's mist OC, there's foam OC, and the relevant distance is different for each of those. It's also
what is the minimum distance for all of them?
The minimum distance is 1/4 of an inch. I can spray you with OC from 1/4 of an inch from your face. That's the minimum distance.
So, gentlemen, if I understand correctly, let's get us back on. I want to keep both of you from I'm sensing, to be fair, and I think our audience is getting a little frustrated that I'm sensing condescension from both of you on this topic.
Yeah, because I'll say this as someone who's trained other officers.
Let me just finish my point, Nate.
Okay,
Nate, let me just finish my point. Okay, to the extent we can avoid, I can urge each of you who I love you guys like brothers, and I respect you. To the extent I can urge each of you to try to avoid that kind of tone, I think we'll have a more conducive conversation here. I also want to make the point that it sounds to me like you're having a debate. And just my audience, so the audience is clear here. We're trying to figure out. Nate is alleging that the reason, and correct me if I'm mistaken, Nate, that the reason that the initial officer could be found liable of murder here is under a theory of felony murder, that because he engaged in a felony prior to the whole scuffle of the 3 officers on top of him, but basically the shovings that he did of the women and the spray that he did of Pretti, that those are felonies, and accordingly that this could be considered felony murder. And so what I think Andrew has been asking is that really a felony or not? Because just because you hit someone doesn't make it a felony. It has to be. I'm not sure what the yardstick is. Perhaps I'm sure you probably both know. At what yardstick does something become a felony assault? Is that when it's liable to result in serious bodily harm or death?
It all depends. Well, number one, it all depends on the jurisdiction. So that's number one. Because some jurisdictions and also assault is a term in terms of you could talk about fear. Assault is a reasonable fear. So in some places, assault and battery, but in New York, for instance,
we're talking in a criminal context, though.
So I'm saying there's assault harm and assault fear. Assault fear is if I pull out a gun and point it at you, that's a felony. That I haven't technically touched you. And then you have assault harm, where if I punch you in the face and break your teeth, that would be the felony. And in some jurisdictions, multiple assaults in a short time frame can lead up to a felony. The first one's a simple assault, second one would be to higher assault, and then the last one would be the felony assault. And most jurisdictions say if you use something like pepper spray or something like that on top of the physical felonies, generally would make it into a felony assault. But what I'm saying is that this officer who committed, again, 5 assaults that we've seen on camera was unjustified in doing any of that before we got to even the shooting.
Right. And the question is, if they were all like relatively minor pushes, which could not result in any sort of serious bodily harm or death, in that case, there's no felony, in which case there would be no felony murder, even by your yardstick. Right?
Yes, I would concede. Now, I'm saying I concede the felony murder is not a slam dunk. It's something that's going to have to be litigated. Just like I would concede that the felony murder in the George Floyd case wasn't a slam dunk. But the case was made that an assault happened. And the assault led to someone's death, and there was no merger doctrine in Minnesota. That's what led you to felony murder.
Andrew, you have questions?
If I concede your felony murder theory, what does that have to do with the criminal liability of the officer who shot Alex Pretti?
Well, maybe you didn't hear what I said earlier. I said, based on the facts and circumstances, the officers who shot Mr. Pretti, I believe, were justified for 2 reasons. Number one, they were justified when they heard gun, 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 right? That was number one. The second, when they heard the gunshot go off, boom. And then they saw Petty start trying to stand up because they had all back.
Are we in agreement that the shooting was justified? Is that what we're saying? We're in agreement.
Yes,
that the shooting...
I said that earlier.
Okay.
The actual shooting was
all right.
justified.
Well, great. Then we're in agreement.
Was justified.
All right.
I don't believe this was a justified shooting in terms of
what
this officer.
What? I don't understand now.
All right. So
was it justified shooting, or was the shooting not justified? Or
maybe I'll explain to you like a 12-year-old.
Oh yeah, go ahead.
So what I mean by justified shooting is that the actual person who made the shot is justified, because sometimes officers miss. Or, for instance, if I'm shooting at one person and shoot someone else, that would be justified. But that doesn't mean it was a justified shooting in this term, because I believe it's the officers who created the dangerous situation. I believe it was the officers who made the situation even worse. And I believe the officer who created the dangerous situation was not justified and should face criminal liability. That's what I'm saying.
Okay, well, I appreciate that. Thank you.
So I think what he's saying is you can't just say that there's a valid self-defense here, because one of the cops could be held liable based on this felony murder theory.
No, I'm saying number one,
not the shooter, but the guy who did.
Yes, unless the person who shot is the actual person who was doing all this assault.
Right.
Yes, then I would say, yeah, that person's for sure. Now, I'll also say if it wasn't the other officer.
This is what I don't understand, though.
I also want to make it clear. If the first shot was the officer shooting him in the back and not a misfire, then I believe that officer. Then I believe this turns to an unjustified shooter, and that officer is unjustified in pulling the trigger.
Why? Why if the first shot came from a cop, is that wrong? Does that make it more wrong?
Because then you'd have to figure out, why did he release that first shot?
Well, because the guy's resisting arrest and they hear gun, gun, gun.
That means nothing. That doesn't give you a right to shoot. So the guy is resisting, and you hear gun, 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 boom, boom, boom. That doesn't mean you get to shoot him. You can only shoot if you perceive a serious threat, and just by hearing gun, gun, gun.
A gun would be a serious threat, right?
Courts all the time say somebody just screaming gun, gun, gun isn't enough. You have to actually have some articulable thing. I see the gun, or the guy made some fertile movement. And I think the argument you made earlier, like the person was reaching toward the back. If a cop say, hey, I saw him reaching to the back and I heard gun, 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 that would make it more justified. But right now, from what I'm seeing, it is not justified based on the information that we have now.
Can I just ask you about this felony murder thing? Because I feel like it's really, really sus. It's really, and here's why. And here's why.
I agree.
Here's why. I'm thinking back to the Chauvin case, okay? And I know Chauvin was convicted ultimately of felony murder.
Right.
In the case of Chauvin, first and foremost, to those who are not unfamiliar with the concept of felony murder,
Chauvin was not convicted of felony murder.
I thought it was one of them. He got murdered too.
Yes. Oh my God.
Too.
You know what? He doesn't
Felony
know what
murder.
he's talking about. He absolutely
He did. He was hit on all of them.
I'm out of here.
Nate.
He doesn't know what he's talking about. He just said Chauvin was not convicted of felony murder. Like.
All right, if I'm mistaken, just correct me, Nate. Correct me.
Nate.
He's got to know what he's talking about.
All right.
Nate, don't. Oh my gosh. I don't even understand that. That's very disappointing.
It's possible I'm mistaken about that, Joe. I would confess my error.
That's a historical fact. Even if you were wrong on it, it's not a question about being wrong about the law. Like, it's the dumbest. I'm so frustrated with that. I don't know why he would have done that. Here's the point I wanted to make about this whole thing. The whole point I wanted to make is in Chauvin, the assault, the felony assault that they convicted him of perpetrating was directly part of the ultimate murder. That's right. Very different. When we talk about felony murder in general, the reason that a felony murder is considered murder, that is that we ratchet it up from a manslaughter, is because we say you created a dangerous situation here, and now, because you were looking to engage in a felony, you wanted to commit a bank robbery, you wanted to go, sexually assault someone, and now during the course of that whole sequence of events, someone's dead. So even though the death was by accident, we're going to attribute the transfer, the intent you had to commit that initial assault and that initial felony, and say now that intent is transferred over to this accidental death, and we're going to say it's not manslaughter, it's murder. That's what the concept behind felony murder is. I was baffled by the fact that Minnesota was raising up. That normally should be a different type of thing from the actual murder, meaning I'm engaging in burglary, I'm engaging in arson, and now someone accidentally dies. So it's supposed to be two different things, not the same thing.
Right. So first of all, I wouldn't draw any legal lessons from Derek Chauvin. I mean, that was a legal circus.
You're right. But that is something that the court in Minnesota, we're in Minnesota now, and that's something that the court in Minnesota specifically said, even a physical assault can serve as a predicate felony for a felony murder charge. That is the law in Minnesota, that the appellate court in Minnesota.
Well, it could if it's the same course of events.
Right. But this is the thing that's baffling to me in trying to apply felony murder here that I wanted to ask Nate. I'm very disappointed that he bolted on, which is over here, it's a different course of events. That's exactly the point. When this guy's pushing, he's not trying to now continue with a whole felony happening here.
First of all, it's not at all obvious to me that these are felonies. Right. I mean, I think this is perfectly justified law enforcement action to secure the scene of an active law enforcement operation. To characterize these as felonies to me is ridiculous. But even if they were felonies, even if they were a predicate for felony murder, that's got nothing to do with whoever shot this guy. It has nothing to do.
No, and he recognized that. He says that whoever shot this guy, assuming it's not the shover, whoever shot this guy would have valid self-defense.
And a fundamental facet of felony murder is that the predicate felony was something that would be reasonably foreseeable to result in death. So I can write a bad check over a certain dollar amount, and it's a felony. But I'm not expecting anyone to die from that. If I hand the bad check to someone and they spontaneously have a heart attack, I didn't commit felony murder. That's different than if I'm robbing a liquor store and I'm fleeing the scene and I run somebody over. That's what felony murder is for.
Right. I'll tell you, that argument that you're making, I'm not really accepting. And the reason I would reject that argument is because I can understand a DA successfully making the claim that when you start engaging in physical altercation with someone, it's not so unforeseeable that someone may die, that there might be a shooting.
But the physical altercation is over. It's over. All these things that Nate was describing had happened and they were done.
Well, and I think we've seen from these riots that when you push one person, it's not over when that person gets pushed. There's often other people.
But then
that
works
in.
the other way, Joe. It works for the CBP people too, right? They know that what happens in these events is they get swarmed. Every minute that goes by, more people are coming, more protesters, more impeders.
Right, so you're saying that gives more justification for the shove for
the OC. We have to resolve this quickly. We can't. If we sit here for an hour, we're going to have 10,000 people throwing bricks at us. This has to be resolved quickly.
I will tell you what his most compelling argument to me, though, that I don't know that you successfully refuted. And so I'll raise this in his behalf.
Right.
When they're across, assuming that they really were in the car leaving with the suspect that they had identified.
But that's not true. That's patently not. Okay, the car left, right? That's what Nate was saying. The car left, so the crime scene.
About to leave and they get out. That's what he was that's what he was portraying. Assuming that,
but they were still there. If they're still there, it's still in crime scene.
See, the point is that that wasn't necessary to secure the arrest. In other words, now he's sort of broadening the zone when the whole altercation with the illegal is over.
It's just so ambiguous to me. It's like, well, were people blocking their vehicles? It's not like their vehicles have never been blocked before. It's not like this is not a risk that they're aware of. It's not like they don't know they need to move people away from their cars so they can travel.
Yeah, but if they're across the street facing the other way.
But they weren't. They were in the street.
I'm saying these people, from the positioning of the car, it didn't look as if they were impeding that car from driving away from me.
Maybe
I'm trying to be reasonable.
I understand.
I'm trying to be fair.
And I'm trying to be reasonable too. Maybe that's true. Maybe there were other protesters in the street. Maybe there were other cars that also needed to. But none of this is. Remember, to show that this was an unlawful shooting, you would have to disprove their justification beyond any reasonable doubt. These speculative notions about what might be going on without any evidence, that doesn't overwhelm that burden.
Right. I think the criticism that's coming from Nate, and I heard that Robert Barnes also leveled similar criticism, is that they're basically saying that your interpretation of the police right to secure a scene or fend off the mob by basically becoming hyper aggressive, even when unnecessary, is broadening the reach of the government in a way beyond what the Supreme Court is willing to recognize. I think that's where they're coming from.
Do they have case law on that?
Well, I think that's why they're going to Graham v. Connor and Tennessee v. Garner.
Graham v. Connor has nothing to do with creating space from an active law enforcement.
I think Tennessee v. Garner.
Same thing, doesn't have anything to do with that. Police are allowed to create space, a secure zone for them to operate. They're not required to allow protesters or impeders to be on their backs while they're trying to do a law enforcement operation. They're allowed to create space.
Right. Look, that's why I don't know if he's still watching. If he can pop back in here, I'd be happy to bring him up back.
He's not going to pop back in.
But like, I just felt as if I just wish I wish it would have stayed. It would have stayed a little calmer. And I think both of you were sort of needling each other, but. And each side, I think, like the Nate fans think that you were needling, and I think that your fans will think that Nate was being rude. And
well, that's appropriate.
Frankly, I saw rudeness from both of you. Not like crazy amounts of rudeness, but a little more than I was hoping for. But
right.
I definitely appreciate.
Well, I feel bad about that because I hung in here for an hour and 16 minutes.
And I very much appreciate
to make up the Destiny thing. So I thought I was doing you a favor, and apparently I made things worse for you.
No. You were great. Listen, you were fine. You were fine. I appreciate the fact that we were able to have some sort of dialogue here for a little bit, and I wish it would have continued a little bit longer. That's all. But I definitely appreciate you popping in here and you know. And going through this, I'm going to be going through these chats here. I don't know if you need to go. That's fine. You know.
No, I'll hang out. It's okay.
I got all right. I want to.
You definitely don't want to see my chats.
I have your chats here.
Oh, do you?
Yeah, your chats. Like this is from your channel. This one here.
Oh my God! I didn't know. I'm sorry about that. If I'd known that, I would have felt bad.
I was bringing up. See, I don't know if you can see the starred chats here.
Can I interrupt you, Joe? By the way, I do want to say I was very sorry to hear about Nate's very serious medical problems, and I'm glad he's recovered as well as he has. So I only have the best wishes for Nate and his health and a long life and all that kind of stuff. So obviously,
and yeah, I don't sense animus. You know, it's on an issue. So as attorneys, we're just sort of and well, people in general, you sort of always want to feel that you're right, and if you're disagreeing with someone, there's sort of this feeling of the gotcha moment and. Whatever. Anyway, I want to try and just run through some of these chats here. So what I was pointing out to you, just so you're aware, when you share like this, can you see the starred messages when you go in your screen there? You see it says next to live? You can see starred next to it. So the starred.
Okay.
I'm trying to teach you for a moment. I'm going to spend.
Yeah, no, I appreciate it. Thank you, brother. I really do appreciate it.
So if you look at the starred messages, you should see there, right? If you go all the way to the top, you'll see, Linda Richards, Go Seahawks, and J.H. Schwalbeck sent 100 and whatever. The most recent ones, if it comes down to most recent ones, is Branca for SCOTUS, you're the GOAT, from Julius over here. This one here is at the bottom. I don't know whether you're at the bottom or the top, but you can see actually when it has a link. So sometimes they have a link. If they have a link, that means it's coming from your channel. So there's a little link thing by Julius's name, so I know it's from your channel. This one doesn't have a link for it backstage.
Oh, okay.
That means it's coming from my channel.
All right, I think now I'm seeing it. All right.
So that's how you could tell which ones are coming from this, which ones went to you, which ones came to me, and
the starred one. Okay.
In the starred ones, so if you look in the starred ones, you see some of them have a little black link. Like Mexican Iron Man over here. You see, are you at the top of it? Or
he's my guy. I'm at the top. Mexican
right.
Iron Man. Yeah.
So you see that little black link by his icon?
I don't. Did I miss
it?
It
says his name. Okay, if you look in the start thing, you see how it says Mexican Iron Man, his name, and just to the left of that you see his picture, and over his picture there's a little black link, like a little picture of a chain.
Oh yes. Okay, I'm seeing that in others.
All the ones, right? The ones that have chains were sent to your channel. The ones that don't have chains. The ones that don't have chains, like this one here, we're sent to my channel.
Well, I think you're just being ignorant, Joe. Oh, sorry. Couldn't help myself.
That's okay. That's okay. So, uncivil here. There were some questions here. Maybe we'll get to some of these. Mark asked, should state the charges brought and then move to a red state to ensure fairness, that if acquitted, it would be better than federal charges into the future by Democrats.
That's not a thing.
As double jeopardy would apply. So first of all, double jeopardy wouldn't apply because state and federal is not going to do the same thing. Second of all, you can't just take it out of state. It has to be in the jurisdiction where it happened. So those, I like the creativity there. I appreciate he's trying to think outside the box how to protect this guy.
People just don't know. They don't know. No, if it's a state prosecution, it has to happen in the state, in the jurisdiction. So
after debate, can I touch on Donald Trump sending Homan in? I will. I do plan on touching on that. So that'll be after Andrew leaves later on. Uncivil law says Graham v. Connor is used in criminal cases, which we ended up conceding that. Shiloh, thank you for the 10 super.
No, but by the way, I want to give uncivil law credit. I mean, it is definitely applied in criminal cases. I've also seen criminal cases where it's not allowed to be applied because they are civil decisions and they're not criminal decisions. And, the courts get lazy sometimes, and it's an easy standard. They know the cops are trained on this, so the departments won't get sued, and so they apply it in criminal cases. That definitely happens. I'm not saying that doesn't happen.
No.
But from a legal perspective, a technical legal perspective, I think it's inappropriate.
I was surprised when I heard Tennessee v. Garner was a civil case. I was assumed because I thought it was the state of Tennessee versus Garner, but you guys were saying it was a civil case.
So in all those cases, the actual officer who fired the shot and killed someone, he's long since been released from the case under qualified immunity. Mm-hmm. So what's happening is his department is being sued.
It's Tennessee. Right.
It's not a question of is this guy criminally liable and should we put him in a cage for this? Does his department or his city or his state or whatever, are they obligated to pay someone money for this? Those are two different questions.
Yeah.
And by the way, different standards of proof, right? Preponderance of the evidence, beyond a reasonable doubt. It matters.
Right. Shiloh, thank you for encouraging people to sub up to everyone, Nate, Andrew, myself. I appreciate that, and we did hit the goal. Apparently, I haven't checked, but someone sent a super chat saying goal, so I assume I'm here for 3 hours. I'm looking forward to it. Once Pretti interfering with the officers, was he obligated or had the responsibility to let the officers know he was armed and has a permit? I don't know about that. Does he have an obligation to say I'm armed?
So I don't know for Minnesota, but I can tell you how it works. There are some states that have an actual law that says if you are contacted by a law enforcement officer and you're carrying concealed with a license, you have to inform them that you're carrying concealed with a license. I think it's 5 or 6 states that do that. I've never lived in a state. I can tell you when I get pulled over for a traffic stop, if that's not an obligation for me, I don't tell the cop I have a gun on me. I would if he made me get out of the car. Then I would tell him. But otherwise, I don't volunteer the information. But there are a handful of states that say you have to tell the cop if you have a gun.
Right. So I'm going to try to cover the $10 ones. I pulled up all the $5 ones, although at a certain point, I think the more recent ones, I haven't even pulled those up yet. My husband, 18-year-old detective here in South Florida, says officers every day use force to secure crime scenes, investigations, arrests, and people do not obey verbal commands. Yeah.
You see it in every police TV show you've ever watched, right? There's a crime scene, people come in, oh, what's going on here? And the cop pushes people back. I mean, it's normal.
Yeah. Thanks again, In or Snow, her great broadcast. Quality breeds quality. Thank you. Appreciate that. New member for you, Papa Miller. Became a YouTube member. There you go. Glad to see our LawTube contrarian is doing well and using all the strawman tactics to prove his point, just like old time. I thought this made me laugh out loud. So, Mexican Ironman says, I don't understand. 5 minutes later, I still don't understand. And after this, I still don't understand. Shots, drink. It's been a pretty good year for ice. I love it. Nate is being Destiny. Stop this. As a former law enforcement officer who's been OC'd, what does that stand for?
OC is a pepper spray.
I know, but what is it? What's the stand for?
Oh, God, I have to remember. Oleocapsin. Yeah, I think that's what it stands for.
It's the technical name for pepper spray.
Right.
All right. Has been OC. Given you're a former instructor, you know that an officer has to follow instructions after being sprayed. Why not a suspect? And that's a question that he's asking on Nate. Like, just because he's struggling breathing, that doesn't mean you don't have to follow instructions.
No, I didn't get a chance to say it, but if an officer lawfully pepper sprays you and you have a problem following orders after that, that's a you problem. You brought that on. That's not the officer's problem.
Right. Nate is accurate here. The last 10 minutes has been an attempt to disrupt the narrative. He's laying down, trying to derail it, is making it more difficult than to listen to.
Hey, Nate.
No, that wasn't Nate. This happened during the whole thing. When I saw this, I just wanted to say I didn't want to disrupt the flow because that's why I said I didn't want to pull these up and start addressing them as they were coming in. I didn't feel that Andrew was trying to derail. It was that at a certain point, it's like, look, I just want to verify what you're trying to say here because he is going for a while. There was like an 8 to 10 minute presentation that Andrew made, and then there was like 20 minutes that Nate was going on, and he felt he had more he had to cover, and that's fine. But there has to be some sort of like, well, what would you say in this scenario? Does this mean this? That's not trying to derail him. It's a matter of just trying to crystallize what his position is. I don't have a dog in this fight. I'm like, if the cops did something wrong, to me, that doesn't mean they should leave Minnesota. That just means it's another reminder why it is that these protests that Walz is allowing to happen is a terrible, terrible, terrible idea that he's ratcheting this up because there will be cops who will screw up. That's going to happen. And people are going to die. And most likely it'll be Minnesota citizens who are going to die. And that doesn't help anyone. So that's why to me, even if the cops here were totally in the wrong, that doesn't help Alex Pretti or his family or anyone. He's still dead. Whether they're right or wrong, he's dead. His life is done. And I don't want there to be more Alex Prettis. And I think that puts me on the opposite side of the fence from Tim Walz, who I think Tim Walz wants there to be more Alex Prettis because it just makes Trump look bad.
It's a feature. It's not a glitch.
Yeah, exactly. So I think we're getting here to the point of things that I didn't. If I didn't pull up some of your chats, I apologize. I'm not trying to skip over anything here. No, I'm not talking to you. I'm saying because I sort of was skipping past the $5 ones that I had pulled up earlier, but I'm getting to a point that I think these I didn't pull up. Love you, Nate, but each time you attack Andrew instead of his arguments, I deducted a point. You have good arguments, so does Andrew. I'm getting Clarence Thomas versus Tandy Jackson.
Oh, I wish. Oh my God, I'm so humbled. I appreciate that. Have I told you this story, Joe?
No.
So when I got sworn into the Supreme Court bar, I went up there. I did it in person, and I stayed to listen, of course, to oral argument. It was Catholic Charities or something. It doesn't matter, but I'm listening to the oral argument. And because I'm being admitted to the bar, I'm like in the first row. I mean, the justices are 8 feet from me, and so I can see him very clearly.
What year is this? When is this?
It just happened last year.
Oh, cool.
And I'm watching and it was the funniest thing. So you have Chief Justice John Roberts is in the middle, and the justices cascade out by how long they've been on the bench, right? And so Clarence Thomas is right next to Roberts. He's been there forever. And every time Ketanji Jackson, I'm going to put my glasses on to illustrate this. Every time, so there's oral argument, questioning, things are happening. And every time Ketanji Jackson, she says, but wait, I don't understand. And she starts talking. Clarence Thomas does this. He very slowly, he takes off his glasses and he puts his hand on his forehead and he unlatches his chair and he leans back like he's having the worst migraine of his life. And then the moment she's done talking, he comes back up, his chair gets relatched, and the glasses, and he's back in the game. My God, it was so funny to watch.
I have good news for you, Andrew. I have good news for you. Nate is back.
Okay. All right.
Oh yeah. Well, yes.
I hope we're gonna stay civil, right?
Yeah. No. I first, I gotta thank Uncivil Law for calling me. And Uncivil Law said, "Hey Nate, you went in way too hot. You went in very condescending." And he said, "I know you've been, because I've been working on something all day." And he said, you know, I think you waited to the end of the day and you were just looking for an excuse to just say negative things. So I actually went back and watched part of the stream when, like, after Andrew made his thing and I was saying my thing. And then I noticed all the side comments and I was like, oh shit. And that's not me. And that's not me. So,
well, fair enough, man.
So I want to come back and just man up and say, Andrew, I am extremely sorry that I acted that way, that I was condescending in that way. I agreed with a lot of your points, and I don't know why I did that. And I truly owe you a heartfelt apology. I am sorry. That's generally not me, and Joe knows that's not me, and it's just not me. I'm not only embarrassed for myself, I'm embarrassed because I agree with a lot of your points, and I tried to make that point, but I just thought I made it poorly. And I think I was a little upset because I felt like I was not being able to get my point across without getting cut off. And it's not an excuse, but I did watch back. I was like, oh, let me watch back after he said it. And it was, there is no excuse for the condescending tones and the snipes that I was making. I don't know why I was actually doing that. And I really, I came back here not to even debate. I came back here to apologize to you as a man, to say, I am sorry, and I hope you forgive me.
Wow. Okay, can I respond, Joe?
Actions.
First of all, I don't think I'm owed an apology, and I didn't take it personally, so I don't want you to feel that way about it. All honor to you if you feel, how can I put it? You hold yourself to a high standard. And you want to be at that high standard. That's what we should all want for ourselves. And I know you're capable of that. And you're doing it right now in front of everybody. Yeah. So kudos to you, my friend.
Oh, I appreciate it. I'm sorry about, your show, Joe. I didn't mean to, but again, no
apologies necessary.
I just really, I got to apologize to the chat too, even though I hate you fucking guys in the chat. I always hate you guys in the chat. But the right thing to do is come back and say, this was not a debate. This was me sniping at Branca. And it was wrong, even though I think I made some of my points. It was wrong. It was wrong for me to do. And I conducted myself better than that. And that's not the standard I like to. So I just, if I can do it, I can come and man up and say, I apologize for it. So I'm back. And again, I'm profusely apologetic.
Well, what I would say is, let's not make too big a deal of it. Okay?
Yeah. All right. Cool. I appreciate
it. But I do have some questions for you, Nate, and that's why I'm wondering if I can just sort of, because we were talking about the whole felony murder, and I think what I understand, and he gave me a breakdown of his arguments by phone earlier today, which is what motivated me to try and get the two of you in the same stream together. So what I understand him saying is this, that the cop who does the shoving is committing a felony. He no longer has the protection of, I'm engaging in self-defense here. And to the extent, and he also could be liable, if he's not the shooter, for the shots that are fired by other police officers, because it's basically even though from his perspective it might be manslaughter, that becomes a felony murder it could become a felony murder for that guy who in Nate's opinion was wrongfully shoving the women and spraying Pretti. Is that a fair synopsis as to where you're coming from, Nate?
Yeah, like I think I mentioned it earlier, but I'm not sure if I mentioned it clearly. I don't believe the felony murder. I believe the felony murder may get to trial, but I don't think you'd be able to prove it beyond a reasonable doubt. And I think there were issues even with the George Floyd case with the assault felony murder. So I didn't explain correctly that I thought if they can defeat the Graham factors in terms of the removal to federal court to get this as a state prosecution, then under Minnesota law, I believe you could get this person on felony murder, i.e. George Floyd. But if we're talking about the federal felony murder statute, which does apply, I think it's 18 U.S.C. section 242, that felony murder statute can also apply, but I think it's less likely that that's going to happen. Now, when you talk about the dangerous felony, I think Branca is 100% correct. You do need a dangerous felony, but it all depends on what jurisdiction. Some jurisdictions, you need a serious felony or inherently dangerous felony, while others, like Georgia, the felony doesn't have to be inherently dangerous. It just has to be a felony and the death occurs within a felony. So it really depends. It's jurisdictional based in terms of this. I'm not sure what the federal one is, but I know Minnesota, it's not, because George Floyd being subdued wasn't an inherently dangerous felony. It was just an assault, and then he charged him with murder 3.
Yeah, Nate, can I ask you, I'm not trying to be contentious here. I'm just legit. So it's been my experience that the courts generally have turned really hard against felony murder. They feel like it's been abused, right? So they've been tightening up on its application pretty hard, at least in my time practicing law. There was a time when, like, if there was any felony and someone died, it's like, you got it. But now they're like, no, we want to see more than just a felony occurred and someone died.
Yes. So in certain states, I think I mentioned in Minnesota, for instance, there are 2 issues with Minnesota. There's no merger doctrine. So what I mean by merger doctrine for the audience, the merger doctrine concerns when you need the predicate crime to commit the felony murder. For instance, every murder is an assault. So if you have an assault that kills somebody, then all of a sudden it becomes a felony murder. So that's why you have a merger doctrine where an assault can't be the predicate for a felony murder. So Minnesota kind of has it very loose, but then states like New York has that, exactly what Andrew said. It became too crazy, so they limited it to it has to be an inherently dangerous felony. So something like bank robbery or something like something as that's inherently dangerous that can lead to someone's death that's foreseeable, that would lead to felony murder. But again, that's jurisdictional. I think the majority takes Andrew's view that it has to be an inherently dangerous felony, and a minority of states take the other view where it just has to be a felony and a death occurs, period.
And by the way, I'd like to clarify. I had mentioned earlier that Chauvin was not a felony murder case, and Nate checked me on that. And I think, in fact, he's right. I think my recollection was that it should not have been a felony murder case because it was a very twisted way of getting to felony murder. It was like a simple assault, but a cop did it, so that made it a felony, and that was a predicate. But anyway, I don't think Nate was wrong. I think technically on the law, he's absolutely correct. That's what happened.
Yeah, for Chauvin, and I think that's the most people's issues with the Chauvin case, because they essentially used a low-level assault to upgrade it to felony murder and give him 10 years in prison.
That wasn't, to correct you, I mean, I remember screaming about it, the felony murder in that context. The reason that it seemed insane is because every time someone dies, there's some level of assault. In other words, if you shoot someone with a gun, so in that case, when the bullet first hits him, so that's an assault. And then when it kills him, he's dead. So you could theoretically label anytime you punch someone in the face and he falls backward and cracks his head, you can say, oh, the punch in the face is a felony. And now he fell and cracked his head. Now it's a felony murder. You can label every situation that someone dies a felony murder if you allow assault to be the predicate felony that now will raise a manslaughter up to a murder. That was the problem that and I remember Nick Rekieta had this issue with Minnesota applying felony murder to assault in general. That assault should never be a valid felony to be the predicate to raise a manslaughter up to a murder. But just
so you know, I agree with you. But what you're talking about, the concept you're talking about, is called the merger doctrine.
Yes.
And the merger doctrine, it's not universally. Minnesota, for instance, rejects the merger doctrine.
Right.
Georgia is another state that rejects the merger doctrine. So you're right. The underlying felony is needed for felony murder. So essentially every murder could be felony murder to get you life in prison, right? If you accidentally kill somebody, you could say, well, you've had an assault and then you have a felony murder. So you're right. It essentially makes all murders felony murders in that context.
But here's the question I wanted to ask you that I'm glad you came back for me to ask you now. And that is, if I engage in a felony of, let's say, arson, okay? And now 10 minutes later, after I'm engaged in that, I'm no longer, I'm putting a 10-minute time parameter for a reason here, but I'm no longer engaged in this activity, okay? And then there's a manslaughter that comes out because someone sees a fire or something like that. Is that something that is felony murder? Or if I'm no longer engaged, do we say that as long as the incident is going on that spiraled out from it, that I could still be liable for felony murder? I don't know. I'm asking this question out of genuine curiosity.
Felony murder is extremely broad in terms of there's a case out of California which most people use to try to overturn felony murder in most states, where the guy lent his friend his car and his friend said they were going to go rob a bank. So he was like 20 miles away sleeping at the time. They robbed the bank, and then the prosecutors prosecuted the guy who was sleeping in bed while they were robbing the bank with felony murder, and he got life in prison.
Wow.
So felony murder is extremely broad.
Wow. No, because
it's pretty crazy.
Because I was going to say, this guy engages in a felony of pushing a woman, and then later on, then another guy fights, and then there's this other thing, and this is something that Andrew brought up as far as like, at what point do we say this is not a foreseeable outgrowth of the felony? Now, I happen to think that this is probably foreseeable, assuming that we accept the felony murder claim. That I'm not there. But if you do accept it, I'm actually on your side on this issue, that if we accept the concept of felony murder, and this could be a felony murder, I do think that the outgrowth of someone dying because the mob joining in and everything happening there, I do think that meets, like, the Paulsgraf type of standard, as far as that seems kind of foreseeable to me, that these mobs tend to go crazy when someone gets pushed. So,
whoa. That's the mob's problem, though.
Yeah.
If they're crazy, that's their problem.
What I'm saying is, I don't think that that's an intervening factor to say that no one should have foreseen this happening. That when you push this woman here to be able to say, when I push this woman over here, can I foresee that person who's 5 feet away might die? I think that that's kind of, given what we've seen going on.
I would say it has to be reasonably foreseeable. In other words, you're not tasked to accommodate insane reactions to normal conduct.
What's considered an insane reaction, as far as what your mindset is? That if you're the cop there, let's put it this way, Andrew. If you're the cop there, you admitted to me that that the mob tends to go crazy as soon as there's any sort of interaction. So it's not insanely unforeseeable. It's very foreseeable that someone else is going to end up in a whole melee when I push A, that B next to, who's 5 feet away, is going to end up in a melee in 30 seconds later. That's not at all unforeseeable, given what's happened in Minnesota for the last month.
But I don't think we can have criminal laws that govern our society based on what insane people do.
Yeah, but I do want to make the legal disclaimer, is that foreseeability piece, the foreseeability that it has to be kind of inherently dangerous, that is on not every state and every jurisdiction adheres to that rule. Minnesota, for instance, doesn't adhere to that rule. So I think on the law and on fairness, I think Andrew is 1,000% correct. That should be the rule. But we're talking about a place where
I agree. It definitely should be the rule. I agree. It should be the rule. I'm just saying, like, I think that if we see history, if you know when you go into an insane asylum that people there are going to act crazy, right? So when you go into the streets of Minneapolis right now, you know that the mob is going to act like a bunch of children who are lunatics.
Yeah, I agree with that.
And I think that that's part of your mindset when you go in there.
Hey, can I throw something else into the mix?
Yeah.
Not to change the subject, although it does change the subject. But of course, we all know. Nate mentioned it earlier that if these officers were to be prosecuted, charged, indicted in Minnesota, the Trump administration would just move it to federal court, and the federal court would dismiss it under the supremacy clause. Right? They say these officers were operating in Reed-Neagle's Supreme Court decision, these officers were operating in the course of their official federal government duties. That falls under the purview of the federal government. The states cannot prosecute that conduct. Well, but what about if Minnesota does not attempt to indict these officers today? What if Minnesota just waits, and in 2028, Tim Walz becomes president of the United States? And his DOJ, when Minnesota decides there's no statute of limitations on murder, when Minnesota decides now we're going to prosecute these cops for murder, these CBP officers for murder, and the Tim Walz administration says, you know what, we're not going to move this to federal court. We're not going to get these dismissed under the supremacy clause. These officers are subject to murder prosecutions forever because President Trump cannot pardon them from legal liability under state law.
Yeah, well, I want to make two distinctions here. It's not the federal government that gets to move it. It's the federal officer, the defendant, who by right gets to move it to federal court to make the argument. And then when the federal officer, if they're charged in state court, indicted, the federal officer by right can say, I want to move this to federal court. And then it moves to federal court because it's supposed to be fair for the federal official. So now when you're in federal court, the first thing that comes across the judge's desk is a motion to dismiss.
Sure.
And that motion to dismiss is based on two things. Number one, the first element is, were you acting under federal authority? And then the second is, was your conduct unreasonable under the Graham standard? And if both of those answers were yes, you were acting under federal authority and your actions were reasonable under Graham, then the case would be dismissed. So I think what you're right, they would just essentially allow this. They would do is just say, okay, let's hold this until the next president. But
right.
Even then the next president says, okay, the federal officer will still be protected by Nierman because they can demand that.
So Nate, I think you're 1,000% correct on the actual law. But just today, for example, the Trump administration won a reversal in the Court of Appeals against a lower federal district court judge who had put an injunction against Trump for ICE use of force, right? Mm-hmm. So we know these federal, that means that federal court injunction was lawless. Yeah. It was not proper, right? So we know these federal court judges, I don't want to get political, but they don't always make the right decisions, right? That's why we have appellate courts, right?
That's true. And the officer would be able to appeal up. So if they're denied at the district court, they can appeal all the way up to the Supreme Court. If the Supreme Court takes the case. But I agree. It's a risk. It's a risk, and I would rather not. So you would almost want him to be charged now to get it done with. But
if I was his defense attorney, I would want him to be charged now and get it right up to federal court. That's the Department of Justice of Trump will be actively defending him there and get it dismissed. But I think that's the reason we're not seeing them being indicted right now.
Yes. I would say because there's no statute of limitations. Yeah, it's going to be
because if you charge him now, right, he has a right to a speedy trial, right?
He has a right to a speedy trial, and he has a right to take it to federal court. So yeah, it'll be tough. But the federal court would be in Minnesota. But then you would take.
But it's all of Minnesota. Yeah, right? So the grand jury you get, the petite jury you get, is not just Hennepin County. It's not just Minneapolis. It's not just what I would characterize as far leftist. It's half of Minnesota, like 43% of Minnesota, is red.
Yeah.
So
most of
right.
Red.
So if you're drawing from the whole state, you get a very different jury pool than if you're drawing just from Hennepin County.
No, that's true. That's true. And to be fair, like when you talk about the Renee Good situation, I think that they may be waiting for something like that. Well, after this, because they can still charge the officer. But I think in the Renee Good, even if you get to federal court, that I think there's a stone cold that you can't get any cleaner of a shoot than that. The guy was shooting while being hit by the car. Like,
all right, so let me ask you about that, man. So, of course, the big criticism of the officer is like the second and third shots, right? That's what I hear. Mm-hmm. That maybe the first shot through the windshield was legitimate, but the later shots were not. What's your thoughts on that?
I think that's I think the people who are making those arguments are making a ridiculous argument, because the Supreme Court has made it very clear that would be considered a single use of force. I can pull up the case. Let me see if I can pull up the case. But in the case,
if you can't find it, by the way, Nate's 100% correct. That's right.
In that particular case, officers were chasing a man and his girlfriend in a car, and they were driving down the highway. And the guy that ran into some people, ran into like the officer's car and everything. So he was a dangerous threat.
Right.
Eventually, he got cornered in a parking lot. He tried to get away, and officers fired 15 shots, all boom, 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 in 10 seconds. Now, the court said specifically that because all those shots came at one time, it was 1.5 shots per second, that was going to be used as one use of force, because of just human's ability,
right? Reaction time,
time, and everything. Now, when you come to Renee Good, you have essentially 4 shots in under a second. So you're talking about 0.2 seconds per shot. So, and I was arguing with Pisco, who's a lefty, about this. He was saying you have to reevaluate under every shot. So the first thing, while we're in the live stream, I said, quick, Pisco, move out the screen, move. And he was like, what are you talking about? And I said, I gave you 3 times as much time just to move in front of the screen. Then this guy had to evaluate between each shot. There is no court that's credible who is going to look at the second and third shot and not treat this as one use of force. So I understand people are making that argument, but I think any career prosecutor knows if you're talking about 0.2 seconds between each shot, it's just physically impossible for someone to be able to think that fast. You're talking about faster than a computer. It's impossible.
Right. And by the way, sorry, Joe, as someone who's done a lot of shooting,
you're like one of the best shooters I know.
0.2 seconds for each shot is like normal. That's not hard to achieve. So you can get 5 shots off a second. It's not that difficult. And the Renee Good shooting, because I timed it, it was actually closer to 0.6 seconds, which actually is good. I think that's good for the officer. That means he shot and took his time to realign his sights, and he just wasn't burning off the magazine into the target. He was being deliberative about it. But it takes time. We all know this driving cars, right? If suddenly the car in front of you brakes, it takes time for you to react, right? To see the brake lights, to understand there's a danger of rear-ending that car, of stepping on the brake yourself. The same is true of initiating deadly defensive force, and the same is true of desisting deadly defensive force. You have to, your brain makes a decision to stop shooting, but your body accommodates that decision a short time later, 2/10, 3/10, 4/10, 6/10 of a second later.
Yes,
I think what we see going on with that, it's from if you want to give the benefit of the doubt to the left, which is probably always a mistake. But if you want to try to give the benefit of the doubt, there's been so much breakdown of the Renee Good shooting that people cannot appreciate just how fast it was, because everyone's watching what exactly happened. Where was he standing? Where did it hit him? Did it not hit him? Everyone's breaking it down frame by frame by frame by frame by frame. So the 0.6 seconds feels like it's like 5 minutes.
Right.
And that's why I think a lot of people are like, oh my gosh, how can you justify that shot? He shot her in point blank in the head right through her window. And they're not appreciating just how bam, 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 bam the whole thing was, because they're so used to watching it in freeze frame, frame by frame by frame by frame by frame. So that's if you want to give them the benefit of the doubt, although we never should, because they're always looking to twist.
What do you guys think about So the Don Lemon thing, right? I did a breakdown, and I'm assuming I found initially this probable cause for arrest, because probable cause is such a low standard, right? He was there, probable cause for an arrest.
It should be a higher standard than it is, by the way, as a criminal defense attorney. It should be more probable than not. Isn't that what probable cause means? That's not how we do it.
No. It's if you believe this, if you believe a crime has been committed, reasonably articulated, and believe that the person who you're about to seize committed that crime. But I would say in the Don Lemon case, though, the issue the magistrate judge came up. That most people don't understand. Magistrate judges are not Article III judges; they're statute judges that just work for the judiciary. So they're essentially clerks for the judge. But
right.
But in the magistrate judge's reasoning is that when you watch Don Lemon's live stream, which I did, every time they asked what his intent was, he was very clear. My intent is to go and film the protest. My intent is to go and do journalism, whatever that means. My intent was to go and that was boring before and after. And to have a conspiracy under the KKK Act, each person would have to agree to the ultimate conspiracy. We're all going to rob the bank. We're all going to go in there and protest. We're all going to do this. But Don Lemon, his specific intent was not to agree to do that, but just to agree to film the protest. And in that's why they didn't believe not only Don Lemon, but if you look at the affidavit from the officer, it was Don Lemon and his crew they removed from the complaint because they said that those people all were particularly had intent to just go in and film the protest and not be a part of it. So it's an interesting legal quandary because the appeals court essentially said there's probable cause, but we're not going to force the judge to sign the probable cause, which I just don't understand.
Well, I'm with Nate there. So listen, I think it could go either way. I think Don. Is it Lemon or Lemon? I never know how to pronounce it.
Right? It is Lemon, but people mockingly call him Lemon.
Okay, well, I'll be respectful. I'll call him Lemon then. I think he. If you ask me, I think he was probably there for a politically energized purpose, not just to be an impartial journalist. But I think the standard should be the burdens on the state. Before you can drag someone into a criminal trial with all that expense and all that risk, you should be able to meet a very high burden before you can do that. And even if I think it's likely that Don Lemon was not acting in good faith, that shouldn't be enough. That shouldn't be enough. It should be more than that, a higher threshold. So do I think this judge was maybe politically motivated? But look at the substance. It is different, right? He is a journalist. I mean, maybe he's a fired journalist or whatever, but he is in a role of, he's going to report these events to others, to us. The actual protesters are not really doing that. It's a little different. And I don't think it's wrong for the judge to acknowledge that. I think the real problem here is that we've gotten to a point where we as a society just do not trust the judges to be impartial. Yeah. We don't trust their judgment. So we have to be suspect of every decision they make. Yeah. And I think that's the real damage to our culture. It's not what Don Lemon was doing in this particular event. It's that when a judge makes a call like this, we can't trust that he's being an honest umpire.
Right. I did find the case that we were talking about earlier, and you guys are gonna love this language. It's called Plumhoff, and I don't know why. Plumhoff v. Rickard. Here's the language: the Supreme Court, multiple shots fired in rapid, continuous bursts will be treated as one single use of force for the Fourth Amendment analysis, not as separate, independently judged uses of force. Supreme Court citation, Plumhoff. So that is about the second, and that's 1.5 shots per second, and here we got 4 shots within one and a half seconds. So it essentially, Plumhoff shows that if somebody's making the argument that each shot is going to be judged separately, they just cite them Plumhoff and say,
I can tell you from my legal experience where this tends to be a problem is not where you have a rapid sequence of shots. It's where there's a series of shots and then there's a pause in the action. And during the pause, a reasonable person would have perceived that the threat has been neutralized, there's no justification to use force anymore, and then they shoot more. that puts you in prison for sure.
Yeah.
But that's the difference. It's not a relatively continuous series of use of force. It's a use of force, a pause where reevaluation was possible and should have been done, and then another use of force. That second use of force has to be independently justified.
That's correct. That's correct. And I think that's, and again, I made the point very poorly, but when we were talking about the next case, that was my point about the use of force, because and I don't know why, but I disregarded your retort, which I think was actually a very good retort. How each push, for instance, was a use of force. It's essentially an assault. But in the circumstances, the officer could make the argument that I'm trying to keep the area safe. But I think when you do look at the totality of the circumstances, the fact that the other officers were already in the car, the fact that they were about to leave, I think that argument kind of falls apart, because if they were all outside, you could make that argument. But I think if that one officer actually got out the car to confront those individuals, that's now you have to kind of judge what's the reason that you're making these. So we can surmise that it may be because of that. We can surmise that they may be trying to arrest them. But I think it would be now up to the officers to justify that those particular uses of force. And what you're saying may be the justification, but it would be on that officer to now make to now justify those assaults.
Right. By the way, I'd like to add, first of all, kudos to you for coming back, Nate. Huge credit to you for coming back. But I'd also like to give credit to Kurt. You say it was Kurt who convinced you to come back.
Because I was gone. I was like, oh, I'm done. Blah, blah, blah.
That is a good friend. And that's a guy with good judgment. And kudos to Kurt.
Yeah, and
for making the right call.
And the audience was just all that. I'm pulling up one chat after another here where they're all just like blown away how you came back. So
in the way you did. As soon as he told me, I'm telling you, I looked at it and I remember you had said something and it really sparked me. I said, oh, I got to go back. You had said something and I was like, oh, that's pretty good. And then I said something like quirky back to you. And I was like, why would I do that? Why wouldn't I answer the question? But then I was like,
let's not dwell on it. I'm not dwelling on it.
But I'm just saying, I just came in too hot. So I was like, oh, shit. And
I just want to point out that this guy here, J.H. Schwalbach, who asked me to check locals in Rumble, in locals, he sent me a $20 tip saying, I would invade Iran to get a Joe Branca Nate show once a month.
I will say this, Nate, and I have to say it. I am enjoying this conversation with you a lot more than the prior conversation. This is great fun.
Me too. Because you know what? It's. I'm not coming with an agenda. I'm not coming to fight. I'm coming to actually do two things: listen, learn, and that's what I do that all the time. I listen.
Of course, you don't have to agree with me, right? I don't care if you agree or not.
I know.
Right.
It's not about disagreement. It's the way you disagree. And I was very disrespectful.
Well, don't worry about it. Let's let that go.
Yeah.
I would love to do this every month. If we could do this every month, I'd be on board for that.
All right, 27th of the month it is. Every month. There you go. Boom.
The cycle.
Oh, I do want to tell. I do. Well, I was going to tell everybody on my street, but
the last Monday of the month.
I do want to tell everybody. I just got some really fantastic news from the doctor, so everybody knows about my big, huge brain tumor. But so they were checking to see if it was cancer going around. Come to find out, I'm in like total remission. So it's seemingly when they cut the part of my brain tumor, when they took it out, they left like 10% in, and it triggered an immune response. So my immune system like killed the rest of the tumor. So when I went back to like the scans, they were like, your scans came back totally clean.
That's awesome, man.
But the only problem is I got a big like hole in my head right here until the brain kind of fills it back up. So like when I bounce, so it's crazy. But no, God has blessed me so much. He's really blessed me, and I'm so happy. But we got the news recently, and
that's amazing.
Amazing. So
amazing.
That's great.
And
thank you guys for all your prayers and everything.
I was assuming that tumor was the part of your brain that told you I'm always wrong. So I was like, oh, good. They got out the best part. So there you go.
It sounds like now your brain gets to get it even bigger. That sounds like a plus.
Gotta squeeze all this thing. No, because this thing's been in my head for like almost 10 years, I think. So it's been in my head for almost 10 years, just growing. So it's been insane.
So I've been going through these different chats here. If I see a question,
what does that mean?
He's asking when you'll become the attorney general.
Oh, no. My goal is this, my friends. My goal is this.
Nice.
Hey, quick question. So what do you guys think about the attorneys? Like, I think Pam Bondi needs to be fired. I think she's got to go. She's like, what is she doing? She's like,
that girl has got to go.
What's going on?
She's terrible.
And don't get me wrong. I'm a 2A guy. Now, this last shooting, I'm going to say it. When the hell did we become the whole you can't take a gun to a protest thing? When
that's not me.
I'm like, no, I'm just saying. I'm a member of the I'm a member of what's it called? I got the stupid backpack of now I can't remember the fucking name of the place because it's so late. But anyway, I'm a 2A advocate. I advocate for it all the time. But I've got a lot of people sitting here arguing that that you can't take a gun to a protest, even if it's a legal gun. And I'm like, this was the argument they were making at Kyle Rittenhouse, all the liberals. Remember KyleRittenhouse? He had a gun to the protest, and it was a legal gun. And now they even
saw the same thing in Michigan with the COVID protest.
Yeah,
they came there and they were all packing. I'll tell you, it's true, but it's true that 100% you should be allowed to bring a gun to a protest. Although I think SCOTUS would allow a state which bans bringing a gun to a protest. I think the Bruen case.
There are a lot of states. I can tell you, there are a lot of states that ban bringing a gun to a protest.
Yeah, and
I'm not saying that's constitutional, but they do it.
Seemed to recognize it, even when Bruen was expanding. It seemed to recognize that. I think that under Bruen that probably would still be legal.
I think it might.
Yeah.
So, for example, at the founding, we had before the Second Amendment was ratified, we had rules against carrying guns at polling places on election day. Right? It was a very limited scope geographically, very limited scope in terms of time. But that was something our founding fathers considered acceptable. So if you say, well, we're not going to allow it, you have a general Second Amendment right, but we're not going to allow it at a protest for a particular period of time, it's hard to see how it wouldn't pass that threshold.
Yeah. So that being the case, but I would say that if you do legally bring a gun to a protest, you better be damn certain that you're not going to be one of those people who are going to engage in jostling a cop, because and that's the thing is so many of these protesters are really just activists who are looking to stand in the way and engage them
and be a martyr.
Yeah, I mean, they don't think they're going to be a martyr. They feel LARPing as if they're in some army. And if you saw the signal chat that they have, they are acting as if they are at war with the federal government, and they have this whole undercover thing where they're trying to they're assigning people to different positions, and they have the city of Minneapolis in different grids and say, you cover this grid, you cover that grid. It's like as if they're literally,
it's a paramilitary organization. We're not actually dealing with a protest anymore. We're dealing with a paramilitary effort,
which is being aided by the local government.
Right. So the only appropriate response is actually a military response.
It's in the Insurrection Act. That's right. That's the only appropriate response. Now, it seems today as if Tim Walz is starting to back down from it. I think he's afraid of the Insurrection Act being declared. It seems as if he's, today he had a conversation with Trump. This is some of the stuff I was planning on covering in hour 3 because I never dreamed I'd keep you guys here for this long. But it seems as if he's starting to back down. If he backs down, there won't be an Insurrection Act. If he does not back down, I'll tell you right now, I do think that the letters we've seen them sending out, from Pam Bondi and the follow-up that we saw today, Carolyn Levitt basically was making the same demands that Trump made on Truth Social. They're laying the foundation to present the case to the American people that, hey, Trump needs to invoke the Insurrection Act.
Joe, did you see the 8th Circuit decision today?
No, I didn't see that.
All right, so this is the Minneapolis Circuit. They had a where can we? I'm not trying to pimp my mugs, but the unelected black robe tyrannical inferior federal district trial court judges, they had a judge basically issue a preliminary injunction against Trump and ICE saying, if ICE does anything in terms of use of force, they have to answer to me under threat of contempt of court.
What?
And Trump appealed it. And just today, the 8th Circuit Court of Appeals came back and said, yeah, we're not doing that shit.
That's
You don't get to do that. And I think that 8th Circuit Court of Appeals, what they were hearing when they were writing their opinion, they were hearing the helicopters of the 82nd Airborne landing in Minneapolis.
Yeah.
And they were like, if we let one of these crazy judges tell Trump he cannot enforce federal law in Minneapolis, what else is he going to do but invoke the Insurrection Act?
And we're going to be under curfew, 8 p.m. Everyone's going to be back in your houses.
You'll be looking at guys on your street with machine guns, Humvees, tanks. That's what the Insurrection Act means.
Yeah.
But there are two things that I do want to throw out there because I disagree with. I think the organized protests, that's been happening since George Floyd, civil rights movement, people call each other and organize and stuff like this. I think what makes this one a little different is because it seems like they're actively trying to impede law enforcement, essentially violating that law. So I think that may be the issue. But I'm not really as concerned with even the COVID stuff and January 6th, where people kind of, because you got to get people together. So that doesn't bother me. But what does bother me is if you do bring a gun to a protest, I think you have to, personally, what I think is that you have to be extra on your toes, because you do know that gun, like I've been in places with other cops where they drop their gun on the floor and then all hell breaks loose because there's a gun on the floor.
Those cops.
Yeah. But and you don't know, it's very, if people knew how often cops will like lose their guns, it's crazy. Like it's insane. But I would say there's also an issue of federalism here, where state sovereignty, I think, also has to play a role, because the state can say, we're just not going to enforce federal law. And that'll force the federal government to do it. But I think the problem that you're having now is that the state is at such an extreme end of it, where we're not even doing crowd control for, to protect. Because if let's say in this situation, if you had the local police doing at least minimum crowd control, I don't think this guy dies. I don't think Renee Good dies. And I think the state has that obligation.
Yeah, I concur.
On people, right?
Yep.
So I want to ask you guys this. I think this is a pretty good question, because you're talking about bringing guns to protests. Is it resisting if he was taken off guard by a violent assault by officers? Just comply doesn't work if you're suddenly mobbed and not even given the ability to peacefully comply. Now, you can make the claim that, and I think that Andrew was making this claim when he first was laying out his case, that when he tries standing back up after he's down on his knees and he stands back up, that's not compliance. That's the moment where he's resisting. They're pushing you to your knees and you stand back up. That's not compliance.
To clarify, I think what I would say is that the law enforcement officers could readily perceive that as noncompliance.
Right. Okay.
Yes.
All right.
Yes. I'll
what would you recommend to someone in this type of scenario, though? You're saying that you should be able to bring guns to a protest. What about this particular scenario that this guy's describing here?
I would do what Kyle Rittenhouse did. So Kyle Rittenhouse walked all around Kenosha with an AR rifle. He killed a bunch of people with it. But when he approached police, have you seen the photos of him approaching police? Hands up, right? That's what I would recommend. The difference between Kyle Rittenhouse, because I see all these parallels being drawn in social media. Well, Kyle Rittenhouse had a gun at a protest. Yeah, but he didn't get in a fight with police while he was doing it. That's the difference.
See, if you look at this video, this is what you were talking about earlier, Joe, about him. I think after this first shot,
we can't see it.
Yeah. I've shared the screen. There it is.
I got it. Yeah.
If you look at this first shot, when you hear the first shot, right? This is why, now this is, again, I'm making a big assumption, so understand this is just an assumption. I think this is a misfire. And the reason why I think this is a misfire and he's not shot, because after you hear the first shot, I want you to look. This is going to be a slow motion. You see how his leg moves up? He's trying to get up. We'll look at it in slow motion because this is slow motion here. So you'll hear the shot and he attempts to stand up and his hands behind his back. First shot. Now watch his leg. He's trying to stand up. And I think the officers hearing the gunshot and he's trying to stand up.
It looks like a fight.
It looks like, and his hand is behind his back.
Right. That's bad.
All those officers. So and that's why
Right.
I said I agree with you. I think all those officers there are justified, because if that's happening in real time, I'm going to shoot that guy. If I'm here with a gun, I'm going to shoot that guy because I heard a gunshot. People said gun, and he is trying to stand up.
Yeah, and by the way, there's a lot of people out there in our community who've been shot before and are still around. I mean, shooting someone does not, it's not like a laser beam. It doesn't instantly neutralize them, especially a 9mm round. I mean, some people are shot lots of times and then they still kill the cop that shot them. So these are not instant neutralizing mechanisms. You have to observe what's happening to determine whether or not the target's been neutralized. And when you shoot an actual, not that I've ever shot an actual human, but it's not like a paper target where you see a hole. You don't know. You don't even know if you've hit the person. You don't know for sure whether you've scored a hit or even a decisive hit. So all you can do is judge by their physical reactions to what's happening. And if they're standing up, it doesn't look like a decisive neutralizing hit.
Right. And I'll tell you something, when you looked at that, when you pulled up that freeze frame there, it doesn't look like any of the officers are in a shooting position. At the moment that shot, that's why I think that it's probably correct assertion that it was a misfire from the gun that was removed from him, because none of them look as if they're primed, taking aim at him and shooting. They're all sort of reaching for their guns. They're in different positions when you hear that pop. And that's why I think this was a misfire. I think this is a terrible tragedy that gun went off. And it was like almost like this is a series of events that God orchestrated to take that man at that time. It's like that was his time.
I do want to show, because there is there's a competing theory about this. And
hey guys, I have to step away for 1 second because I have to go to the bathroom. I'm sorry. Sure. I don't mean to interrupt. You can continue without me, but I didn't want to be rude and just leave without an explanation. So I'll be right back.
Okay.
If you look at this, I want you to. I've shared the clip. Oh, okay. I want you to. So if you listen to this, I want you to look at this officer with the gun, and when you hear the first shot, his arm is going to like recoil a little bit.
Does it?
Look, watch. You see his arm like recoils a little bit?
No, I don't really see that.
Yeah, some people are saying that little jerk is the gun recoiling. I'll play it again.
He's in such a terrible position to shoot the guy.
Yeah, and so if that's the case,
not the guy on his knees, it's about the guy in green, right?
Yeah, so they're saying the guy in green lets off the first shot. The shot hits him in the back, and the guy reaches, because you feel the fire in your back. He reaches for his back, and then that's when everybody else. So that's the second interpretation.
I'll tell you why I think that's wrong. Mm-hmm. I think if you're shot in the back, you don't try to stand up. I think the last thing you do is try to stand up if you're shot in the back. I think you go down. Your reaction is not, let me lift my leg up and try standing. If you ever had back pain, if you ever got shot in the lower part of your body, I've never been shot at all.
But I've been pinched before and I've grabbed it, or you
but you wouldn't. I mean, but if you play forward like another half a second, that's right after
standing up.
Yeah, you wouldn't do that if you're in back pain.
Yeah,
you know what I'm saying, if you have a bullet in your back, you're not trying to do that.
That's true.
But
then you there's also like what's it called, adrenaline, emotion. You're in the middle of a fight.
Yeah, I'll tell you right now, I've had back spasms, which I'm sure is much less than being shot in the back. Yeah, you fall to your knees. You had no choice. It's not like you're thinking. I was playing basketball as a 20-year-old, and all of a sudden I got a back spasm, and it wasn't like I had a choice or a thought. It's like boom, like I'm just down. And because it's when your lower back gets hit, and that's where the gun is trained, it's very hard for me to believe that the first shot came from the guy in green. I really think it was a misfire.
Let me also, I want to clarify one thing. The felony murder logic, because I wrote it down because I wanted to make sure I understood what you guys understood what I wanted to try to say. So what I was trying to say for felony murder, it's 18 U.S.C. section 242. Because the officer initiated unlawful assault, which is a deprivation of rights under 18 U.S.C. section 242, that forced Pretti to defend himself, because he now, if you believe it's unreasonable force, you can now employ self-defense under federal law. And that struggle led to Pietti's death. The officer could be criminally liable for the death. That's the felony murder logic. That was the logic I was trying to employ.
Okay, so it was you're saying the officer using force against Pretti particularly.
Yes, because the officer who initiated
that makes more sense to me.
Conduct at the beginning, that was the pushing and all that stuff. Then that forced Pretti to defend himself and the other, because you can use self-defense to defend you or to defend someone else against unlawful force. So that's the way we kind of attach it to get to 242. And I'm not sure if 242 requires a dangerous felony or not, but it could. And so I got to look that up.
Question for Nate. Branca mentioned earlier that cops can create a secure area and prevent protesters from entering the area. Couldn't the BP agents say that that's what he was doing? In which case, in fact, I think that's what Branca's point was.
That's exactly what I expect they would say.
Right. I would say you can say that, but then I would say let's go to the videotape, because I think on the videotape, what people I think missed is that the officers had all gotten into the car to leave. And matter of fact, the car was actually put into drive. You can see the car lights light up, and it goes from to white to drive. The officer actually has the door open before they're about to get into the car. And then there's words exchanged, and then that officer leaves out the door, walks toward the woman and pushes her. And then he pushes the other woman. So if that was the case, then I would expect the officers to be out securing the area. But if all the officers are in the car ready to drive away, if that officer jumps in the car, they drive away. But so I don't think it's reasonable under those circumstances.
And I think you're right, Nate, in the sense that if the facts you're stating are correct, that I think that's a totally reasonable take. But we saw how many cops were there at the end. They all weren't in one car.
No, there were two cars. There was the car in front.
So we don't know what's happening with the other car. We don't know if other officers are still out and about on the scene. We don't know if cars are being obstructed by people in the road. I'm not saying I know the answer. I'm just saying it's ambiguous from the video.
Well, I would say this, because I have the initial video, and when you see the initial video of just the scene, the officers are in the car, and then the second video from the scene, you can see the officers actually get out of the force. So not only the officers in that first black car, but there's a car right in front that the officers all get out, and that's obviously because they're in this, this one officer's in this battle, and you have to protect your partner there, especially understanding how it is there.
But that would be reasonable then.
Of course, that's reasonable. Yeah.
Yeah. Okay. All right.
Just JH is bringing up an interesting thing here. So no one brought up the fact that this guy Pretti was a member of the Signal Chat group. He was there to do what he did. I don't know that would be a factor, though.
No, because the cops on the scene wouldn't know that, right? So for use of force law, I mean, for kind of a broader political understanding of what was happening, I guess that's relevant. But for a justification of why they shot him, unless the officer who shot him knew all this, it wouldn't be relevant at all.
Yeah. It's his subjective knowledge at the time.
Right, exactly.
Yeah, at the time force was used. Here is what I'm talking about.
But I will say it gets a little complicated, right? Because you have a lot of officers involved. They're seeing different things and they're reacting in different ways. So, for example, say you had one officer in the group, C. Pretti.
It's okay. I missed
Pretti repeatedly be non-compliant, right? That officer would have a reasonable expectation that the next time he encounters Pretti, he's going to be non-compliant. I mean, a pretty good indication of what people are going to do next time is what they did the last time. Not every officer would know that, but it would inform that officer's judgment. And then when that officer engages maybe more aggressively than a naive officer would do, the other officers are going to back up that officer, right? They're going to rely on his judgment of the situation. So just the fact that there's a lot of different officers involved really, it complicates the analysis.
Well, that also could complicate the analysis with respect to the shoving of the woman. That maybe that woman was repeatedly, being hostile to them in ways that mandated that aggression.
And I think we have reason to believe that's true, right? So these were people who were following around these
probably
CBV
not the first
officers.
rodeo. It's not that first rodeo together.
Right. They've seen each other before.
A day earlier, 2 days earlier, and maybe perhaps over and over again.
Right. They're familiars.
But I would make the claim though, like I have it up on screen. You can see all the officers, the two cars the officers are in the black car and the car in front. They're kind of double parked. Yeah. And they're all loaded up into the car, right? And this officer is loaded up into the car. And then when I'm going to play it from that point, you'll see the door. He's like, go leave, go leave, go leave, go leave, go leave, go leave. And then that's when this person seems like he just has enough, closes the door, and then that's when the fight or whatever starts happening.
Yeah, I'd like to know what happened there. Like, I would like to talk to the officers about their perceptions there. Were they concerned that people were going to, physically block their vehicles, and that's why they wanted more space? Or what was their rationale for getting back out of the cars and coming out? I'd like to hear that.
But I would say yes, for that one officer, and also too for the law enforcement nuts out there, this 1 versus 3 thing usually doesn't work. Usually you're not supposed to engage 3 people.
But he knows he's not by himself, right? I mean, he knows he's got a dozen.
Because generally you don't do a 1 versus.
But I will say this for sure: cops cannot use force just because they're pissed at you. That's not allowed.
Yeah, that's why I think ultimately the cop. This was a rogue cop. I think this was a rogue cop, and I think this cop just got pissed off. Maybe they said something, but just to understand, whistles, yelling, screaming, all of that, the Supreme Court has clearly said is constitutionally protected. And again, City of Houston v. I forgot the name of the person. Just look at that case, and the Supreme Court, they literally passed the law saying you can't scream at police while they're doing this, and the Supreme Court said no. That's a First Amendment constitutionally protected right. Blowing a whistle is a message of protest, so you are all good. So
all right, so Nate, let me ask you though. I'm not disagreeing with what you said, but to the degree that shouting these high-pierced whistles, they disable the ability of these officers to communicate with each other.
100%.
Right? That would have to. I mean, because I'm watching this and I'm thinking, maybe someone said the gun's secure. I would never be able to hear it over these whistles and these shouts. In this stressful situation.
Well, it's also, we should realize that the people who are filming are the ones whistling, so the whistle's probably louder for us than it is for the police officers. I agree with you that it probably discombobulates the officers to some degree. But one of the things I was thinking about is that
if you were having a conversation with your wife in a restaurant and the table next to you was blowing whistles, right, it wouldn't make it any easier, right?
100%. No, I agree. I agree with you in principle. I'm just saying in actual application, when they're there, as far as what they can hear, it's going to be annoying, and it's purposefully annoying. They're trying to basically be as annoying as possible, and it could make it harder to hear. I just don't think that in practice is actually quite as loud as we perceive it, because the person who's filming is like blowing up into the phone.
A different question then for Nate and you. So the statute I've been citing, 18 U.S. Code 111, assaulting, resisting, impeding officers. It literally reads, you forcibly assault. Okay, let's put that aside. Resist, oppose, impede, or interferes. Are these whistles interfering with these agents' ability to carry out their duties?
I have that question. You see, when they told me this thing that the Supreme Court said you're allowed to use whistles, I was very surprised by that, because the level of whistles we do see there, as much as I just made a defense that the whistles are not quite that bad, with I've heard enough whistles over videos for the last month to last me a lifetime, and I'm like, I don't understand how it is that that's not impeding their ability to communicate with each other in scenarios where it's probably vital for them to communicate with each other. So now I'm flipping back the other way and saying that, like, I don't understand how it is that whistles are considered okay if you're blowing an air horn and now no one can hear, the officers can't hear each other.
I mean, the question would be, the threshold would be, is the noise you're making, you can imagine like levels of noise that are just protest, right? And then there's a higher level of noise that's actually impeding communication of the law enforcement officers. Those are two different things.
Well, what I think is we're doing what's called a mistake of law, because what we're doing is reading the statute and saying this is what we believe the statute should read. But the way you kind of digest this is you say, well, what's the case law say about this particular statute? How have the judges applied it in various cases? Now, this 18 U.S.C. Section 111 has been applied in the Eighth Circuit, which we're talking about.
Yep.
They've made it very clear that there are some elements that have to be had. And the case is, I pulled it up, it's United States v. Street, 8th Circuit.
By the way, folks, this is a lawyer doing lawyer work right now. You're watching it real time.
So you still have the other thing up on screen if you want me to add that to the stage. I was gonna bring up 18
no, that's it. But yeah, you can bring up 18 U.S.C. Section 111. So it's the way the court interprets it. So the way the court interprets it is that, number one, you must have force. And I actually have the quote from the case, which I can bring up.
Because it says forcibly assaults, forcibly assaults.
No, but they've made force to be a requirement.
But are sound waves not force?
No, they don't consider that to be force. They consider that to be a protected communication.
Okay.
But I want to make it very clear too. Force doesn't have to be I hit you. It could also be the perception of force.
Fair enough.
Yeah. Like that. So I'm talking about the Eighth Circuit particularly. So that force requirement from the United States v. Street kind of hamstrings the prosecutors in the federal district there because they need that requirement. Make that argument that the stuff are for under the statute, and especially when you have the court case that says, these type of have a constitutional right to, that's a message, then I just think it's a no starter. The whistles are, but to be fair,
so let me ask you,
Nate, is one of the few circuits that when filming, they don't consider filming to be a First Amendment protection.
So let me ask you like kind of a law school examination question, right? Okay. So what if someone came out with a megaphone and if they blasted that megaphone at your head, it caused permanent hearing loss? Would that be force?
Yeah, because you're talking about a physical injury now. Yeah.
Okay.
I think physical injury is different. Yeah. Yeah.
But of course,
physical injuries. Yeah, definitely.
But physical injury to hearing is not a threshold. It happens incrementally.
Yes.
Right.
Yes.
So,
I agree.
So these piercing whistles in an officer's ear. I mean, above a certain decibel threshold. I mean, I shoot guns and I drive cars and motorcycles and stuff, so I pay attention to this. You lose. Basically, you're taught you lose hearing every time it happens permanently. Mm-hmm. So you forget to put your hearing protection on at the range. You fire one round. Ow! Yeah. Now you remember you lost that hearing.
That's good. Yeah. Well, I would say I think you make a good argument in the microcosm of, let's say, in the particular facts of that particular case, but I just think, and I pulled up the case, City of Houston versus Hill, United versus Street. The Eighth Circuit has made it very clear.
I don't have it here. If you're pulling up for me, I don't have it here.
No, I haven't pulled it up. I can pull it up. Hold on, I have it right here.
No, I'm not contesting your citation. I'm just saying,
he was just asking.
You can imagine if the same court was hearing a case where people permanently lost their hearing, maybe they'd say that was too much. That's not free speech.
Yeah.
Perhaps, but I think I think the default is that it is going to be considered free speech.
Well, there are time, place, and manner restrictions on free speech, right? We don't allow people to do free speech everywhere all the time anywhere.
But that would be the local jurisdiction in the state of Minnesota and the city of Minneapolis. That wouldn't be a federal question.
It wouldn't? The First Amendment's not a federal question?
not when you talk about time, place, and manner as to like how it's being executed. Because if Minnesota doesn't restrict them, I don't think that you can say the federal government is now coming in and deciding to restrict you.
Is that true? I mean, I'm not contesting you. I find that surprising.
Here is
that time, place, and manner restrictions are not federal law.
They are federal law.
Are they?
You're right. Yeah, they're federal law. He's right.
So you're saying so hold on a second. So you're saying the federal government can say that we are restricting people from using whistles with
but they can say what is constitutionally protected and not.
Exactly, yes. But they have clearly said, for instance, when like things that the First Amendment is very expansive. For instance, strippers. There was the G-string cases. I don't know if you guys remember that from law.
Oh, let's talk about G-strings. I'm all for it.
That's what we called them, the G-string cases. But they were strippers who the town passed the ordinance that women couldn't have to be fully clothed, and they sued under a First Amendment. And the court came down and said that they were conveying an erotic message to their patrons, and they had a constitutional right to convey that erotic message, but the state had an interest in the health and safety of the parishioners in this. So obviously, sexually transmitted diseases and so forth like that. So they could regulate pasties and G-strings, but they couldn't ban it. So it was interesting. But here is this case. It's U.S. v. Street, 8th Circuit, 1995. Force is necessary element of sections 111, which you're talking about, convictions. However, that element may be satisfied by proof of actual physical contact, right? You actually touched somebody.
Which happened here.
Which happened here. Or proof of such a threat or disability of physical aggression toward the officer as to inspire fear, pain, bodily harm, or death. Now, and they have a whole bunch of cases, because there's a whole bunch of other cases that also stand for this proposition. But in every single case, when it talks about whistles, yelling, screaming, it's all constitutionally protected. So when you're talking about things that are constitutionally protected, it's just harder. So essentially, all that other language in 111, the Eighth Circuit kind of renders it meaningless unless force is actually accompanied.
Well, unless there's contact. It says here contact.
Yeah, contact is force.
Right. So this guy had contact. So I mean, I'm distinguishing between what actually happened here and the hypothetical of whether whistles should be.
No,
but Alex Pretti made contact.
Yeah, but the question is, if his contact though is justifiable because the initial contact against the women was unjustified, in that case, and I think that's where Nate was starting. In that case, his contact would then become justified, and you couldn't say that his contact is a violation of 111.
Yeah, because again, he would be making the defense. My contact was incidental to stop an officer from assaulting or using unnecessary force against someone else. Now, if the court deemed the officer's force to be reasonable and necessary, then he loses that defense. You can't stop an officer from using reasonable, necessary force, but only he has to convince a judge, and then you get what's known as, you get a jury instruction, that if you believe the defendant was acting in self-defense or defending someone else, then he would not be guilty of this particular crime.
Right. And I will say, I've worked a couple cases where someone shot a cop and it was self-defense. It was a justified use of force against a police officer because the police officer was using excessive force against him. Yeah. But I will say this, I've seen it a couple times in 34 years of practicing law. So it's not common.
That's got to be hard. Yeah.
Shiloh asked, when Nate's point of view changed, the woman was attempting to unarrest the arrestee. We no longer video eventually come out. We always find out later. So
yeah, I think, yes, if she is trying to unarrest someone, that I think you're right here in 111, right? You're using physical aggression. I think you're 111. And
but aren't they all, are we really disputing that's what they're trying to do? I mean, it looks like it to me
that they're trying to
unarrest, right?
The women, I don't think the women were. They didn't try to. Didn't to me.
No, but Alex Pretti was trying to unarrest.
But sorry. So there's a contradiction here. Remember, we said the women weren't being arrested.
No. I understand, but Alex Pretti might have thought the women were trying to be arrested.
But then, so you can have two issues, and I think that would be the argument at trial. They thought the women were trying to be arrested. He was trying to.
So he was intervening to prevent that, right?
But then his argument would be, I saw an unreasonable use of force, and I was trying to defend. Right.
So
that would be the argument.
Yeah, no, I agree. That's the argument that would be made. Yeah. Right.
And self-defense, you don't have, it just doesn't have to be me. You can employ self-defense to someone else.
Like, holy shit, this is like a completely different Nate. What happened? Do you have a twin?
No. You know what happened? I realized that Branca, you are not my enemy. And Joel,
I'm not your enemy.
Yeah, and you know what I realized? Like, I came in.
No, I love this guy. This guy is great to debate with.
No, because we're talking the law, and I love I love talking the law.
Gopher asks, what are your thoughts on the video apparently showing the victim SIG spontaneously discharging, and that's the first shot heard?
Now, my take on this is, if it's the officer who makes that first shot, then we have to make the analysis on why that officer released that first shot. If it's the SIG that makes the first shot, then I believe all those officers who responded with deadly physical force were justified based on the circumstances they had in front of them. But again, like I said, I think the only other officer who may be in some trouble, and that's why I think you see all this movement in the background at Department of Homeland Security, is because they had body cameras. And if this officers, if they say, well, none of these previous assaults were justified, then you can have a real problem with that one officer. So I think me and Andrew actually agree with most of the analysis. Like, I don't think any of his analysis about the shooting is incorrect. I just think you just have to take that first part of the situation into account, as the court said in Barnes v. Felix.
So I can say this about, so, all right. So this, the pistol that was Alex Pretti's pistol. It was a SIG 320. I own a bunch of these guns. I own a bunch of them. I bought them years ago. They have acquired a reputation as guns that will go off when they're not supposed to go off. I don't shoot mine anymore. I don't trust them. So is it possible the CBP officer took the gun, the SIG 320 off Alex Pretti, and it just went off by itself? That is possible. The guns are not supposed to operate that way. And SIG has been sued, I don't know, 100 times over these models of guns going off. Now, I don't know if it's a real issue with the gun or people are just suing. I'm not an armorer. I can tell you, I don't shoot my 320s anymore. They just stay in the safe. I don't trust them. But it's possible. But it doesn't really change the legal analysis, right? It could have been this gun going off. It could have been a car backfiring. If the cops who had their guns out on the suspect heard what they reasonably perceived as a gunshot, negligent, car backfiring, whatever, that would have fed into their decision that, oh my God, I'm facing a deadly force threat.
But would you agree that, let's say it wasn't a misfire, it was one of the officers had his finger on the trigger and the gun went off? I would say the analysis at that point was that officer justified to employ deadly physical force in that moment? And I think that's a harder bridge to cross.
I don't actually think it is. So I think so. Let's imagine that the guy in the gray coat who has Alex Pretti's gun, that the gun goes off by itself, or he presses the trigger negligently and makes the gun go off, right? Does that create criminal liability for a different officer who responds to that? Right. So we're in agreement there, right?
Yes. Right.
Now, for that guy, the guy in the gray jacket who fired the gun, or the gun just went off, let's pretend he was negligent, right? He put his finger on the trigger unintentionally. Okay. The gun just went off. Could he have, say, manslaughter liability, right? So he created a negligent risk, a reckless risk of death or serious bodily injury because he made the gun go off.
I agree.
I guess you can make that argument. It doesn't feel very compelling to me. In other words, he wasn't trying to do that, right? He didn't know he was creating a reckless risk. And it's not like a drunk driving homicide.
And in the same sense, if the guy with the green, it would be the exact same thing as if the guy with the green shirt whose gun is pointed at his back negligently pull the trigger, so that too would be a manslaughter. It's the same manslaughter, because then all the ensuing shots and all those other shots that are coming out there are all coming because someone screwed up and pulled the trigger that they didn't intend to pull. And I do think that that's a fair case that a state can make for manslaughter.
Well, I may have not been clear with the point I was trying to make. The officer who grabs Pretti's gun and it misfires, I think even if it does misfire, I don't think there's any criminal liability. You can maybe make that argument, but I really think that's a stretch. The argument I was trying to make is that if, let's say, one of the officers who were surrounding him, if the first shot came from one of their guns, so the officers who were around it and one of the officers shot, then I think that officer who shot him with that first shot, or shot at him with that first shot with their gun, not with the other gun, you would have to make an analysis of that use of force, because you got to ask
100%.
Why is he initiating that self-defense?
100%.
And that's what I'm saying. The break here for me with this particular case is if that first officer shoots him, then I believe you now go to unjustified shooting, because he'd have to determine what happened. But if that other gun misfired, then I think that clears all the officers because they responded to a deadly physical force.
Sympathetic fire. Right.
Exactly. Yeah.
Based on what you guys are saying, would it change anything if the Trump administration enforce the issue and bring the case federally now instead of the state doing it later, or it comes to a preemptive pardon? You can have a preemptive pardon. There's no problem with preemptive pardon. If Trump wants to give this cop a preemptive pardon, that would protect him from any subsequent federal government, a Democrat federal government, bring charges against him. But the concern here is that the state of Minnesota would find a way to come after this guy sometime down the road. And that's something that Trump's pardon, preemptive or at any time, wouldn't help him with.
No.
So
yeah, you still got state charges, separate sovereigns, so you can't.
But I still think that they try bringing him state. He could say, you have to come at me in federal court.
Because it's Nagel.
If you wanted to. See, Nate makes a great point. That it would be the officer who would go to federal court to make this argument. And I'm not saying that's wrong, but I'm not sure that's what's happened in the past. I think normally what's happened in the past, it wasn't the officer who went to federal court. It was the federal government who went to federal court to protect their officer. So I'm not saying that Nate's wrong, that an officer couldn't do this, but I'm not sure that's happened before. And
but wouldn't this be a fascinating thing, though? Imagine this. Imagine Trump gives him a pardon. And then the state of Minnesota comes along and says, we want to charge you. And he says, I want to go to federal court because
he's already has a pardon there.
And now that I'm in federal court, here's my pardon.
Right.
Like,
we've never seen this before.
No one's ever seen that. Would that be a factor in him precluding him from moving to federal court? I don't see why it would be a fact. I don't see why that would be an inhibitor from him being able to bring it to federal court. I just think it's a funny scenario where he's like, no, I want to go to this place where I already have my get out of jail free card that I can wave in your face.
Well, it's a difference between the process and the finding of fact. So the finding of fact is going to be based on state law. So it's essentially like a diversity jurisdiction in civil law, right? It's diverse. You have a diversity jurisdiction. So so in federal court, you are actually applying state law. So if he's convicted under state law, Trump can't pardon
that
the process. He can pardon if you're being charged under federal law. He can pardon that. But
that's a great response.
The process of being in federal.
That's a very smart response. What in case you're not getting what Nate was saying there, he's saying that just because he gets into federal court, that doesn't mean the pardon would help him there, because it's as if he's in state court. It just happens in federal court. It would still be the state charge. So okay, cool. No, great job.
Yeah, yep, 100%.
And the only problem with Nagel is that, and if you're an officer and you're a federal officer and you're charged in state court, because they could indict him, I think by right the officer gets to take it if he wants to. And I think if I'm the officer here, we're going to federal court as fast as possible.
Right.
It's not I don't want this.
Right. Nagel is your safety vest, right?
Yeah. It's literally your safety vest. And like you say, it may not have happened before, but in this case, Nagel.
But I don't see how it is. How is it a safety vest if in fact you're getting the state charges in federal court and a pardon from Trump wouldn't help him?
No, it's a safety vest for federal.
Yeah.
From federal charges down the road.
Right.
Yeah, but he doesn't need that if he has the pardon from Trump.
Unless
And don't forget
unless a Democrat is president next time.
That's true.
In which case we're all dead anyway.
The first bite at before you even get to the trial, before you even get to any evidence, the first thing Nagel demands is that the federal court entertain the motion to dismiss based on, was this officer acting in their lawful capacity as whatever agent? Yes, that's an automatic yes. And then we go to the Graham factors. Was the force being
outside
used necessary, reasonable, or outside the scope? And if it's no, then if that's a yes, then you're done. You don't even get to charges.
So you have to understand that under Nagel, the state's position under Nagel, okay, we have to understand this. So basically you had a federal judge who was being threatened. He was assigned, I think it was a U.S. Marshal. It was a federal law enforcement officer. And sure enough, the judge was attacked. And the federal law enforcement officer killed the attacker. And the state said, you murdered that guy. You didn't have to kill him. You murdered that guy. We're going to charge you with murder. And the federal government said, we don't give a shit what you think it was. You can't prosecute our guy. So imagine if that marshal literally took a machete, just cut that guy's head off for no good reason. The federal government's making the same argument. And the state is saying, oh my God, there's literally nothing we can do against this guy. That's the tension in Nagel.
Yeah. But Nagel is based on the supremacy clause. So generally, like when you mentioned supremacy clause, that's Nagel. Nagel is supreme, and I'll say this: most cases don't get through Nagel. Nagel is usually a full stop. It's over. So
Mike is asking here, him bringing the gun to the protest, if I'm not mistaken, wouldn't the concealed carry be invalid if he failed to have a mandatory valid state ID on his person with his concealed carry as stated in the Minnesota concealed carry statutes? Any thoughts on that, gentlemen?
Yeah, the first thing I would say is all these laws are unconstitutional. So they're all unconstitutional.
Yeah, but now if the cop wants to say that this is an illegal gun there, right?
My understanding is it's a $25 fine if you don't have the permit on your person.
But I would also suggest too, let's say, for argument's sake, the gun was illegal. Again, if somebody has an illegal gun,
you can't kill them.
The use of force analysis is still the same.
Right.
Did they make any type of fertile movements? Did they reach for the gun? That type of thing. I
agree with that.
You can't just so this whole aspect of the gun being legal or not legal doesn't really.
That came up a lot during the Rittenhouse case where there was questions really about the legality of the gun, which ended up being perfectly legal.
Ended up being legal.
Yeah, but
nobody shot this guy because he happened to have a gun. He was exercising his Second Amendment rights. He had a spare magazine. That's not why he was shot.
His opportunity to comply was not to make himself a traffic cop and to not to get between law enforcement and someone they were dealing with. I think it was so dumb of him. I think it's the stupidest thing in the world.
Well, what's the difference between this and Kyle Rittenhouse, right? Kyle Rittenhouse went to a protest, even more egregiously armed than this guy, right? With a full-blown AR rifle slung over his body. He went to a protest where he knew violence was happening. The difference is that when Kyle Rittenhouse was encountered by police, he did this. And when this guy was confronted by police, he fought him.
Well, I think like a lot of the pushback I get with the Kyle Rittenhouse analogy is that open carry versus concealed carry, and people are making a big deal about the concealed carry piece of it. So how would you guys respond to the fact that Kyle Rittenhouse open carry is a different animal than this concealed carry issue?
You want to go first, Joe?
See, the open carry to me is something that, again, we're coming to the whole question as to how he's dealing with the cops. I mean, is he waving that thing around? In the open carry, we saw how he had that gun pointed down the entire time. Every single time he's purposefully, it enables him to manifest that he's not being a threat with this gun just in the way he's carrying the gun. It might be intimidating to people who are not used to being around guns, but the reality is, since he's not walking around like this, he's walking around with it slung downward. When he's engaged in the cops, he has his hands in the air. I mean, it's just as far as a practical thing, I think that the open carry enabled Kyle to manifest that he was not trying to use it in a threatening manner, and the only time he was going to use it was in actual self-defense, which is what he ended up doing. So, with respect to the distinction, that's my takeaway on it. What are your thoughts?
So my perspective as the guy who carries a gun every day, I carry a gun every day. I carry concealed. And I think every American citizen has the right to carry a gun open carry. And I encourage all of you to do that because that means you get shot first.
I don't know why people open carry.
I don't know. I would never open carry. I would never do it. I mean, I guess if the only way I was lawfully permitted to carry was open carry, I guess I would do it. But if I have the option, I don't want that other dude to know that I have a gun until he's hearing loud noises. I mean, I want to look like the most undefended, helpless person in the world until I have to present my gun. Now, having said that, I think every American has the Second Amendment right to carry open if they want to carry a rifle if they want to. They should, if their state laws don't allow it. The Constitution should allow it. But you have to understand that when you're carrying a weapon openly, you're raising red flags for somebody. I consider myself a Second Amendment absolutist, okay? I think every gun law that preemptively infringes the right of law-abiding, mentally sound American citizens to carry guns is facially unconstitutional. But if I'm sitting in a Starbucks and you walk in with an AR rifle slung across your body, you have 100% of my attention. You have 100% of my attention because that's not normal. That's not normal. You don't carry that for personal protection. You don't carry that for self-defense. You're trying to make some kind of statement. And it might be a statement on the right or it might be a statement on the left. I don't know. But I know that's a lethal weapon. And if I'm there with my wife and children, you have 100% of my attention until you leave that establishment.
But I do want to ask you guys, you gentlemen, about the gun, because I've made the claim that this whole gun thing is pretty much just a ridiculous red herring, because the cops didn't know he had a gun until he was literally on the floor and his jacket went up and they saw it and the guy said gun, 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 and grabbed the gun. Yeah. So I think it's only relevant to that portion of it, because people make it sound like he came there with a gun, they brandished the gun, all that stuff. Nobody there knew that there was a gun until that moment. So everything before that, I don't think we can impugn the cops with that knowledge and say they were acting with that knowledge, because the only time they knew is when they saw it and the guy said gun, gun, gun.
So it's I would say it's two different conversations, right? If you want to have a political conversation about whether he showed up with malice to do bad things, then the fact. Listen, again, I carry a gun every day. I've carried a gun my entire adult life. I don't typically carry a gun and 60 rounds of ammunition. That's a lot.
That's a lot.
In my experience, that's unusual for personal self-defense. Might you consider that in terms of his motives? Maybe. I don't know. It's for a jury to decide.
But I would say
in terms of the actual use of force event, none of those officers knew anything about that. Yeah. So that could not have been driving their decision-making. So in that context, is completely irrelevant.
Yeah.
Can cops use the LRAD? I don't even know what that is.
Is that the license plate thing? Do you know, Nate?
No, I don't know. LRAD. No, I don't know. LRAD. But I haven't been in this like 15 years ago.
I don't know what that is either. I would ask a question further. What about a device that's loud enough to cause permanent hearing damage? Not saying that's what's happening here.
Yeah,
so
no, I mean, the statutes that define death or serious bodily injury usually define serious bodily injury. Part of it is loss of a bodily function, right? Yes. So if there's a sound device that's going to make you deaf, that's loss of a bodily function.
And we are talking about different types of, like there's a difference between a speaker and having the aided device that's different than people with a whistle and people just screaming, yelling, because the First Amendment protects, you're trying to convey this message, but in the form, and that's where you get the time, place, and manner restrictions, the form in which, like for instance, in New York, you could scream as loud as you want all day, but as soon as you use some type of microphone or some type of device, that's where they regulate. You can't use a device to amplify your voice. So that's why, I don't know if you ever saw those, the George Floyd protests, where one person would say something like, say her name, and then everybody else would say her name. That was to amplify, because that was the way you do it legally.
So one of my community just told me LRAD is long range acoustical device. Oh. So it sounds like an acoustical weapon.
Oh, so what are your thoughts on that? Can they use a long range acoustical?
Same legal standard. If it's causing loss of bodily function,
cops can use that. They're asking cops can use that.
Well, yeah, cops can shoot people dead. I mean, but again, depending.
And it's again, they would have to justify that use of force, and to make sure it's proportional, reasonable, based on the circumstances, and what a reasonable officer facing the same set of facts would use that off. So it's not the weapon; it's the reasonableness of the weapon in the situation at hand.
If whistles are a First Amendment right, wouldn't I have the right to flash lasers at law enforcement too? One affects the sense of hearing, so what stopped me from pathing an officer's sight? Well,
same thing.
I don't know about that, because the Supreme Court has definitively weighed in on affecting their hearing and has not weighed in on the sight. So I don't know that I would say.
Why would the legal paradigm be different?
Because the sense of sight is something that we tend to rely on a lot more than our sense of hearing, just to navigate the world.
Sorry, I'm not sure the Supreme Court has said it's okay to strip another person of their hearing to make them deaf.
Not make them deaf, but temporarily impede their ability to hear.
Temporarily, lasers don't do that. Lasers cause permanent damage.
The case that we're talking about is City of Houston v. Hill. It stands for the proposition First Amendment protects a significant amount of verbal criticism and challenge directly at police officers because they passed a statute saying you can't scream and yell at police officers. But they said it's valid protest conduct. Blowing whistles, screaming at police officers, constitutionally protected, not a criminal act, rendering the officer's interference for that thing unlawful from the start. So the officers
not being interference, you said, right?
Yeah. It's you. It says,
but you can imagine sounds loud enough to interfere.
Right? Yeah, that's what this chat is actually bringing up.
That would be the thing. Mm-hmm.
This chat is bringing up that the whistles they use can produce 135 decibels, instant injury to ears at 120.
That's an assault, as far as I'm concerned.
The whistles are an act of aggression.
But you know what the problem is that if we're talking about just the legal standards, you'd have to go into court
and establish that those whistles.
And the first, if you're against me, the first thing I'm bringing up is here's a Supreme Court precedent. Whistles and these are all protected speech. Now, you may be able to get over that by saying, well, this injured me, there's physical injuries. I think you could make that argument, but that's an uphill climb because you're arguing to now change the law.
Okay, so I would, from my perspective,
to qualify the law. To qualify the law.
From my perspective, as the guy who just does use of force defense, it's a different argument if you're trying to prosecute someone for blowing a whistle, and if you're trying to defend someone because they used force to defend against the whistle.
True.
That's a good point. That's a good point.
Bit late, my issues. The public seems to be treating them as if they're not officers. Their uniform appears chosen to appear not to be officers. I'm not sure what he's saying there.
I'm not. Yeah, that's strange.
Branca Barnes was talking crap about your evaluation of this case. Please jump on a stream with him. Stand straight. He's dead wrong.
No, I know people keep telling me that Barnes is talking shit about me. It's I don't really care. But
I'll tell you exactly.
Listen, Barnes knows how to contact me. He has my information. He can contact me. If he wants to do some kind of debate, he knows how to reach me. Where is he? Where is he?
His argument is essentially very similar. He's saying that, number one, he's saying that you're not using the proper standard, which is Graham. We went over that. But then he's also saying that you're not looking at the totality of the circumstances. You're just looking at, and that was strictly forbidden and Barnes v. I forget the name of the case. It's the
Felix.
Barnes v. Felix. Yeah. So he's saying you're.
I know he's saying I'm an idiot. Whatever.
He did saying you're an idiot, but he is like his argument has those two elements to it. One, that you're not looking at the totality of the circumstances, and two, that you're making all your assumptions happens to be toward the officer and not looking at the officer's fault in the mix. So that's what his argument.
I appreciate that. Yeah, thanks. I appreciate that.
But he calls me a dummy, and he calls everybody a dummy.
Listen, I just couldn't care less.
That's
I couldn't care less. Listen, I don't wish Barnes any ill. I wish him the greatest success in the world. I hope he makes millions of dollars or whatever. It's fine. But he's just not. Robert Barnes is not meaningful in my life, and so I just don't care.
This whole I see a lot of people want this acoustic sound to mean something and to do something, but again,
the reason is because we've seen so many videos where it just sounds deafening.
They're screaming and it's loud and everything.
It does. Again, it sounds deafening.
The reason the ACLU is going to be all over this. We got Supreme Court precedent. I think you may be able to massage it, but it's a constitutionally protected right.
Yeah, but by the way, for people who don't know, so we watch these videos of this shooting, right, with Alex Pretti, and you hear the bang, 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 bang in the video. I can tell you from personal experience, when even a 9mm handgun is going off within feet of you, it is painful. It is painful to your hearing if you're not wearing protection. Yeah, it's pretty bad. It is really super loud.
I'm sure they all are wearing protection. I'm sure
they're not. None of them are.
Really? Why would they be wearing ear protection?
Because they don't know they're going to get into a gunfight.
You're saying the gunfight. I was talking about the whistle situation. I was talking about if you're an ICE agent, I'm sure you're wearing it. I'm sure you're wearing ear protection.
They're not wearing. No, I guarantee you, they're not. They're not
because you have to be able to hear too,
right?
Yeah. I don't. You wouldn't be wearing ear protection.
And I can tell you when that 9mm pistol goes off and you're not wearing hearing protection, it is literally physically painful to your hearing. That's why you see them flinch. That's why you get that reaction. That's why they jump back.
This guy says, I disagree with Nate. As a former police officer, I would have arrested you if you came up to me and blew a whistle in such a volume that interferes with my duties.
Well,
he's in Iceland.
Congratulations for being a great police officer, but this is jurisdictional based. That's why we specifically looked at cases from the 8th Circuit in Minnesota where this is taking place, and we looked at Supreme Court precedent, which is binding, and this is what they say. So if
I think he also looks like he's from Iceland.
Yeah, because the officer could arrest somebody for this, but they would be violating that person's constitutional rights.
By the way, I feel obliged to mention I was critical of Nate bringing up Graham and Tennessee versus Garner because they were civil cases. He's doing exactly the opposite of that when he's bringing up actual 8th Circuit cases. I mean, that's the governing law in that jurisdiction.
Yeah, but and these cases are just to be, and I should have, instead of coming off so cavalier, I should have explained most cases that caveat use of force and police are generally 1983 claims because it's not generally because of
people don't know what that means, Nate. So explain what 1983 is.
Federal Tort Claim Act.
Yeah, because unfortunately, because of what's known as qualified immunity, most of the officers' cases don't even get to trial. Don't move up the chain
for criminal liability for the officer.
Criminal liability.
Right.
So the only way you can get the change in the law or through 1983 civil tort cases. So that's why Graham v. Connor, Barnes v. Felix, Tennessee v. Gardner, and all these cases cited are all civil cases, but they color criminal law. And that's why you'll see in every single, for instance, Alaska, like I think I showed you before, Alaska, California, every jurisdiction goes to the Graham v. Connor standard. And in all of these cases, for instance, in New York, when you go to the actual law, Graham v. Connor is installed in law where if a cop violates Graham v. Connor, they're essentially violating the law too. So
and I saw a post by Kurt earlier. He was saying, "Well, Graham v. Connor is applied in criminal cases all the time." He's absolutely correct. It is applied in criminal cases all the time. My point was only that it doesn't have to be. Because there are courts, I've worked for courts that have not applied it in criminal cases, but it is commonly applied in criminal cases. There's no question about it.
Yeah, to answer your question, it's King James now. I don't think our panel here is aware of there being any case law which distinguishes between one volume of whistle and another volume. So I'm not saying it doesn't exist. I'm simply saying that I don't think Nate, Andrew, or I.
You got to pay us. You want an answer? You got to pay us.
We haven't done the research to find it.
I will say this: I am having a lot better time with this conversation. This is actually a fun conversation. I would like to do this again. This is fun. Just going over and thinking about all these things because I just haven't, I haven't been challenged on the law in a long time. So
I still have a lot of questions about the whole Don Lemon thing because, frankly, I'll tell you, to me, the whole Don Lemon situation, that church invasion does not happen if he's not there. I think that it seems so orchestrated from the staging area and onward that they were looking for the publicity.
I thought we covered this already.
You went through it, and I didn't get to weigh in because I don't know. We just jumped around. So I think you guys are actually more forgiving of Don Lemon than I am because I am. And I'm not very forgiving of him because I don't really believe that thing. And I understand that you have to prove this beyond a reasonable doubt, but I don't believe that thing. I think if you go through their chats, I'm sure that they purposefully wanted to make sure he was available.
Well, that would change things, obviously.
And that this entire thing was staged as performative for Don Lemon's audience.
So if he's actually aiding and abetting a crime, that's different, right?
Right. So, and that's what I think. I wouldn't be remotely surprised. In fact, I would actually be surprised to learn that they did not purposely coordinate for when he's available. You know,
listen. If I were to guess, and I'm just speculating here, I'm not making claims of fact. So please don't sue Joe or me. But if I had to guess, I would say that Don Lemon was completely coordinated with all of this from the very beginning. It was all theater. But when you get to court, especially a liberal court, the judge is going to say, listen, if this guy has even a shade of First Amendment privilege, I'm going to give it to him. Yeah. I'm going to treat him differently than everybody else. Yeah. And Don Lemon has, I don't think it's a credible shade, but he's got a shade of First Amendment. And so I'm not sure why people are shocked by this outcome. Could like a super conservative judge have come to a different finding? Of course. But let's face it. He's been a journalist in the past. He's pretending to be a journalist today.
We're all journalists.
We're all journalists.
No, I'm saying the three of us.
Yeah, no,
journalism is a constitutional individualized right, not a right for a company. A lot of people think it's the right for the company.
So it doesn't surprise me that it's treated differently.
But I will say this though, so we're talking about co-conspirators and whether Don Lemon is a co-conspirator to this crime. Now, to be a co-conspirator, there are three elements that you'd have to satisfy to be in a conspiracy. One, you have to have the agreement, right? We have to come to the agreement that two or more people come to the agreement that we're going to do this thing. This
affirmative act.
You need the overt act. Yeah, correct. Yeah. You need the overt act. So, for instance, in this case, if Don Lemon held the church door open while the protesters came in, you got him. That's the overt act. And then the last is you have to have the specific intent. Now, foreknowledge is not enough. All courts have said that. Just knowing they're going to do something bad is not enough. But if you in some way participate or in some way help the plan along, then you would be considered. So
now, I agree 100%.
Now, the problem with Don Lemon and the court said there are three issues with the Don Lemon case. One, his agreement, as he said in the video, was he agreed with them to go and film the protest while they agreed to go in protest. So they were saying the agreement is an issue. Then number two, his intent. His intent was to go film the protest while their intent was to go protest. So you have an issue with specific intent.
Yeah, that's different. That's not the same.
And then he said third, there was no overt act. He actually waited till the protesters went in, and then he went in after them. So there was no overt act for him to help facilitate it. So with all of those things in place, the magistrate judge said, I just don't see any probable cause for Don Lemon.
Well, I don't disagree with the outcome. I think overt act is a little because I think he was involved throughout. Yeah. So I think that would qualify as an overt act. But I think the other elements you point to, I agree, are vulnerable to attack. And listen, I'm by nature, I'm a criminal defense attorney. I think your argument against my client should be overwhelming, not marginal. It should be overwhelming. And I don't see that against Don Lemon. Listen, I don't like the guy.
I don't like Don Lemon either.
But if he were my client, those are exactly the arguments I would make.
Yeah. Oh yeah. And you know, I know Pam Bondi was mad, and they can go to a grand jury. They can go to a grand jury.
You said Pam Bondi. Oh my God.
But they can take this to a grand jury. But I understand why they're afraid, because you're going into a hot grand jury, because you're going to Hennepin County in Minnesota. And
Nate, you would bring this if you were the defense counsel. You'd say, yeah, bring it to a grand jury. I'll see you there, right? I would.
He's testifying in the grand jury.
I would.
Yeah, Don Lemon. He's even though, don't get me wrong, I think there's enough of probable cause, because I don't know if you guys saw the appellate opinion. The one of the concurrent judges said there's enough of probable cause because it's just a low standard. But we're saying we should.
But isn't that a problem in and of itself?
That's a problem in and of itself.
I mean, I swear I run into this all the time as a criminal defense attorney. I think the standard we literally do not apply a probable cause standard to criminal defendants. We don't do it. We don't literally say we think it's more likely than not that he's guilty of the crime. We basically say, all right, the cops showed up, the prosecutor showed up, he swore out an information. That's good enough. That's what we do. That's bullshit. That's not probable cause.
But the issue that you'd come to with changing probable cause, making a higher standard, is that most people. So the Fourth Amendment requires probable cause to make a seizure or an arrest, and you can do that through a warrant, or the cops can develop probable cause because they can see things happen or whatever.
Yep.
But now, by having a higher standard, essentially something like 95% of all arrests are warrantless arrests based on the cops explaining probable cause. So that standard is supposed to be fluid to allow cops to make those kind of temporary seizures and then have a judge or a magistrate determine if probable cause has been achieved. So that's the rationale about it being so low. But I do agree. I think maybe, but all right. So
I don't disagree with anything you just said. No, I agree 100%.
Oh, because I'm kind of just giving the background. But I would ask, what standard would you replace it with? What about something like the civil standard of not
preponderance of evidence,
preponderance of the evidence, or clear and convincing evidence? What would you replace it with?
Well, what I would replace it with is what it's actually supposed to be. More likely than not that you committed the crime. Unfortunately, in the real world we live in, you can't do that. We have so many criminal and violent people committing crimes that we've had to lubricate the criminal justice system to make it more efficient. So we've lowered the standard. And most of these people are guilty. Listen, I do criminal defense. Most of the clients are guilty. They're guilty. You know, I mean, my job is to hold the state to the standard of proving them guilty beyond a reasonable doubt. But it's not like I don't think they're guilty. It's just the state has to prove it. But we have so many now that we've had to make the system more efficient by effectively lowering what probable cause actually means. And I'm not actually saying we should change it, because if we change it, we're letting a lot of really bad, horrible, violent criminals just go free. I think we're kind of stuck with the system we have. But I just feel on a kind of a political level, a societal level, that it's not where we ought to be.
Yeah, I agree. I definitely agree with that.
Look at Joe sighing back there. He's like,
"No,
oh
I'm
my
sorry,
God, they're talking political. He's lost the show. Joe has lost his show to the Branca and Nate. This is now the Branca and Nate show.
I'm actually frustrated because I lost my Rumble rants when I popped my chat out, and that just it's annoying me.
Sucks.
Joe, yeah. I don't popping your chat out. You're supposed to discuss that with your wife, man.
Well, frankly, that's what you just pretty much summarized every one of those Rumble rants, because one after another just read like that. Like, let's find something we can all agree on is good, like breasts. Like, that's literally one of the chats that I saw. And I was just, another one was about men being pounded. It was just one after another. And that's why I was like, let me pull this up on screen rather than actually having to read this stuff out loud. And yeah. And when I tried doing that, well, they all.
Well, one of the things that guys like me and Nate have in common is we've both been in prison a lot, but only as visitors.
I was there once, not just as a visitor, but that's a story I've already told on my channel.
Yeah. No, but you know what? It's interesting, because when I changed from prosecution to defense attorney, it is a different way of thinking, because you have to stop thinking as, you know, how do I get this guy, and start thinking about what holes can I get to get him off? Because I just recently had a case with involved the FBI and everything, and it's so wild because the cop calls me up at like 8:00 in the morning. I'm like, why are you calling me at 8:00 in the morning? They're like, oh, because they were at 9:00 there, but 8:00 my time, and they're like, oh, we want your guy to come in. I'm like, for what? We want to talk to him. I said, for what? Oh, we just want to clear some things up. I said, well, we can clear them up now.
Right.
So
with me.
So they're like, no. We'd like you guys to come in and clear it up. I said, listen, do you think I'm so stupid that I'm going to have my client come in and answer any fucking questions? The fact that you're calling me to have him come in at your convenience, I was like, we got nothing to say. They're like, oh, well, we'll get indictments. We'll get this. I said, then send me the paperwork, because if you could get that indictment, you would have already had it, and we'd be talking in another setting. But you need my client to come in to give up something for you to get the indictment. And I know it. He knows it, but we're not talking. So that's it. And they get so pissed off. But I had to actually learn how to do that, because I was, I'm so pro police and pro prosecution that I kind of had to wheel that back and say, hold on, what are they really looking for? And it's funny, because a lot of people don't realize people confess a lot. Like, people confess to police a lot. How many times, Andrew, that you go to see a client and they've already given up all the goods?
No, it's too late.
What the hell is going on? Why did you tell them all that?
I have to tell people all the time, I can't help you. I can't help you.
It happens so often.
You gave it all up.
Told them everything? That guy, did he tell him? Did he tell you he was your lawyer or something? Like, why did you say?
I'll be honest. That's why I switched my legal practice from just representing people generally to just having a membership, because the people in our community, in my community, they've received so much instruction from me that I know, heaven forbid they call me, they haven't done that. They've learned enough not to just spill their guts the moment the cops talk to them.
Yeah, I'm just pulling these up here because these are someone Uzellian here is being kind enough to like reshare the rants that I lost.
Oh, nice.
So that's why I was just like highlighting this here, what Uzellian was bringing up, because I just I'm feeling very guilty about this.
Oh.
So Uzellian asked, let's say it's a misfire, what is SIG's civil liability for this?
Oh my God.
Potentially enormous.
Yeah.
Well, I think, to who though? Who would, because again, the gentleman who bought the gun.
The estate of Alex Pretti?
Like his estate.
Yeah, for the manslaughter that resulted from it.
It would be, but I wouldn't even call it manslaughter because it would be justified. So I don't think it would be manslaughter.
No. The liability is SIG. It's not Alex Pretti bought that gun, presumably at a gun store lawfully. It's represented as a product that's suitable for the marketplace. It meets all the safety requirements. We're all allowed to presume that. If the gun is defective, that's a SIG Arms problem.
Yeah.
If that gun just went off, and listen, gun manufacturers are protected from like criminals using their guns to commit crimes, right?
Yeah.
If a bad guy gets your gun and commits a crime, the gun manufacturer should not be sued for that any more than if someone stole your car and committed a DWI homicide. You should be responsible for that. But if the gun manufacturer actually makes a defective gun that kills people, yes, they should be responsible for that. That's just product liability law.
Yeah.
Could the agents call the cops on the whistleblowers for violating noise ordinances? Good luck in the Minneapolis PD to like enforce that.
But he's right. They're right. You could call them for the noise ordinances, but the Minnesota cops have been directed whenever ICE is there, they cannot, essentially, they just leave that area alone and whatever happens, which is even more dangerous because just like I keep saying, if the Minnesota cops just did crowd control, neither one of these deaths happened. Or if they went there and said, hey, you got to move this car, they could arrest you for the traffic violation and you don't have to worry about now we got other federal charges and stuff. Because the federal charges essentially make it, because of this force requirement, it essentially makes it so it has to escalate before they can do something, which I think is dangerous all around.
Mr. Branca's presence is requested for the Jack Show this week. Contact that Star Wars girl for further details.
That Star Wars girl.
No, that's not a small channel. That Star Wars girl.
No, I
like that Star Wars girl.
And by the way, they texted me, they DM'd me, whatever it is. I'm sorry, I'm a boomer. And yes, I will get back to you. I promise.
All right, so I just wanted to make sure that
I appreciate
I conveyed that along, seeing as how someone super chat for that. To answer you, Smooth Brain Crypto, there's no precedent when you're dealing at district court level. There's no such thing as a precedent. It wouldn't be a precedent. Whatever came out of the Don Lemon case, you would have to go all the way to the appellate court and have some sort of decision from the Eighth Circuit before anyone would start talking about there being some sort of precedent. I like the way you're thinking. It's creative. It's a creative thought.
It's actually correct.
Yeah. Well,
it's legally correct.
It would be precedent, but it would be persuasive authority, not mandatory authority. So the other district persuasive, but they're not.
Right. Fair enough. I do think I like the thinking here. That's, that, hey, look, if a pro-life journalist goes into an abortion clinic to interview doctors, that they could say, look, this court, assuming they do in the same district over here, in Minnesota, we're talking about Minneapolis. It was in federal court. So you're talking about in the District of Minnesota. Was
Eighth Circuit? You're talking about the Eighth Circuit?
But District Court Minnesota that rejected Lemon's thing.
Yeah, I see this misunderstanding in the public where something is not law unless you have case law, unless you have precedent. That's not true. I mean, statutes are law. Now statutes by themselves don't have effect in the real world. They don't self-actualize. They have to be applied by courts and to real parties and real cases. But it's not like something is not a law until it's interpreted and applied 100%. By a court. It still exists.
100%. But the point I would make here is this: with respect to the Don Lemon case, this was decided by a magistrate judge, which means not a district court judge. It was decided by a magistrate who rejected it. Then the appellate court said, basically, we think you probably should have granted it, but because the magistrate judge rejected it, we're not going to overturn the magistrate judge.
Correct.
So whether that would be something that's influential or can be used, seeing as how the initial decision was made by a magistrate judge, and the only reason that it was upheld was because they just didn't want to overturn a magistrate judge out of like policy.
Don't we understand what's actually happening here?
This was politics.
The higher level court is saying, listen, I'm an actual district court judge. I don't want to do magistrate shit.
Right. Yes.
Right? I've been promoted above that level.
Yeah.
Right? That's what's actually happening here.
And what they said was, go to grand jury. Take care of it that way. What are you pestering me for? Yeah.
But you know what? They could judge shop. They could. They got a whole bunch of options. But again, I think the opinion. I think the magistrate's reasoning really puts them in a bind. Because they're going to have to because the first Andrew obviously knows this. As soon as you go into the court and you're saying we want you to look at this, they're going to say, what did the other judge say? And now you got to get over that freaking hurdle.
Okay, so I guess what I would say about all this, I consider it nonsense. I think it's all political, but I wish every case I worked on that client was getting the same kind of benefit that these people were getting from. Because normally when you put a charging document in front of a judge, they just sign it. Yeah. They just sign it.
Yeah.
It could be complete bullshit. It could be complete lies. They just sign it. I can't tell you how many cases I've covered or been involved in personally as an attorney where I look at the charging document, I'm like, this is complete bullshit. And when you get to trial, the prosecutors actually never argue any of those facts. They just use that as a way to get you in front of a jury in the first place. It's contemptible. I think those prosecutors should be held in contempt. Should be chastised. It's wrong. So I think the standard for getting these kind of charging documents in the first place should be way higher than it is now. But unfortunately, the standard is you can put a piece of toilet paper in front of a judge with a Sharpie, just sign this, and they'll sign it. And now your client's in front of a jury.
Yeah. Why no sound tools used in SA? Also, Ruski said there were some in hotels. Temporary
Joe,
damage.
that's your Tumblr account, my friend.
Why no use? Also, sorry, YouTube censorship. I can't even make heads or tails out of this.
Right? We know.
I'm sorry.
Sorry, brother. It's okay. Just move on.
All right. Yeah. I'm predisposed to give the officer benefit of the doubt. I'd lend a hand and help out Officer Nate. So there you go. You guys kind of missed the point I was making. The Trump administration should force the case to federal court now.
They can't
get a judge.
How would you do that?
You can't.
Well, they basically prosecute him.
But even if Trump prosecutes him, that makes it worse because then you have the state can just wait. Like it doesn't matter.
But he's saying get a judge to say they acted within scope of their duties and say the use of force was reasonable, and that way you get determination in his factor that he could use as state court.
No, it just
that's what it's called.
Yeah. So the federal court decision saving this guy would be responding to a state prosecution.
Correct.
Yeah. No. I'm a former Minnesota LEO in my academy. We had a former CBP agent in my class. He said the federal use of force standards are much more lax than Minnesota use of force
standards.
Yeah,
that's true.
Would the agent be judged by state or federal standards?
By the federal agent.
Well, this definitely. But there are kind of two levels. The floor for everybody is Graham v. Connor, so you can't go below that. But the state can even restrict you more. So, for instance, in what was the cigarette smoking case? The guy Gardner.
Gardner in New York. Staten Island, right?
Yeah, the Staten Island guy who was choked. In that particular case,
he wasn't choked.
Yeah,
but go ahead.
They were saying he wasn't choked. What they got him on was that it was a violation. NYPD policy said that you could not place suspects in the chokehold to effectuate an arrest. And that came from a case called Anthony Baez, which the cop put the kid in the chokehold and he choked to death and killed him. So police policy. But in that particular case, they said that there was actually probable cause they didn't say probable cause. They said that he violated department policy, but he satisfied Graham because what he did was reasonable under the circumstances by placing that guy in a particular chokehold.
Despite the fact that he was violating policy, that still is reasonable. Yes.
So because violating policy is a factor that you consider within the whole thing. So he was fired from the police department, but he wasn't criminally charged because he was able to satisfy Graham.
Wow, interesting. Guys, each lawyer on this label is 10 times better than that hack legal eagle. That's obvious.
He was crying over this.
Oh my God, that poor! Crazy, I feel so bad for him.
Yeah.
Did he just come out as gay? Is that what happened?
No. Well, I think with these two cases, I do agree with him more with this case, but I think with these two cases, the last case, I think was clearly justified. And I think people were just trying to make it seem unjustified because it's political nonsense. But I think this case where it seems more unjustified, it gives you that moral high ground. So I think he's just jumped on that and just took it. Like, this is what we're going
to do. The message I would send out to all Americans, especially young Americans out there, is that you could be the dumbest lawyer in the fucking world and still make $1 million a year on YouTube. So just do whatever Legal is doing. Just do that.
The guy knows social media. You gotta get credit. He knows social media.
He doesn't know anything about law.
He knows social media. Can the gun manufacturer be liable for faulty product? 100%.
Yeah.
Do any of you think we may get Supreme Court to weigh in on sanctuary cities and the constitutionality of not complying with federal immigration enforcement? What are your thoughts on that, Nate?
100. It's 100%. Constitution.
How is it constitutional? Tell me how that's not a violation of the supremacy clause. This is something I was discussing. I might have been discussing it.
Well, there are a multitude of cases that deal with the separation between. Well, first you got to talk about the 10th Amendment, the between the states and federal, because essentially the states are the fourth branch of government. So, and in terms
not for immigrations,
but what the difference is that. I forgot the name of the case, but there's a Supreme Court case that says the federal government cannot force state officials to enforce federal law, and vice versa. So what happens is that sanctuary cities are saying, well, we will not assist the federal government in enforcing federal law in this particular area. And we also got to remember it works both ways. Back in the Arizona case with Obama, remember, Arizona passed a law that they would arrest and deport illegal immigrants. And the Supreme Court said, well, you can't do that because that's specifically the federal powers. So unless they authorize you to do that, then you can't. Then you can do that, and that's why. So
you saw Biden beat Texas that way when Texas was trying to close the border, and Biden was like, "No, you can't close the border. That's my exclusive.
It's our authority."
Yeah.
So
it's very, very frustrating. But I still don't understand how it is that you can't force them to comply. But to the extent that they're helping harbor them from federal agents, I think that is a violation of the supremacy clause. Nate.
If you're helping them harbor,
if they're helping harbor illegal aliens,
which they obviously are, right? They're providing them with shelter, food, medical care. I mean, that's what harboring means.
Well. Again, I would. We have because now if we have to kind of peel it back. Number one, there are two types of illegal immigration, right? There's the civil version, visa overstays, right? I come here, I'm supposed to be 6 months, I stay 8 months. That's a civil obligation. Then you have the criminal aspect of it. Somebody coming across the border and not presenting themselves to a border agent or proper thing. That's the criminal, the misdemeanor. So in those two instances, I think the analysis would be different. One's a civil violation versus a criminal violation. So harboring criminals would be illegal, but the civil violation, I don't think you'd have that argument.
No. If you're harboring someone unlawfully in the country, you fall within the scope of the statute. So they don't have a lawful presence. I mean, it's different in the sense that you describe. One's criminal, one's civil, but they both fall within the scope of the...
I think this is an interesting question that Lori is asking here. What I actually would expect is likely to happen is we use the term sanctuary state or sanctuary city very loosely, but really it would come down to how that pie is baked. In what way are they serving as a sanctuary city? What steps specifically are they taking in order to label themselves as a sanctuary state or city? If they're doing it, that they're just saying, hey, we're not going to work with the federal government to help you get you deported. In that case, Supreme Court has ruled that's okay. To the extent that they're taking steps to help harbor and insulate you from being detected and found or picked up by ICE agents, that now would likely be something that would be violative of the supremacy clause. That's my take on it.
I don't know the Supreme Court has said that's okay. Supreme Court has said, to be clear, that the federal government cannot compel the states to enforce federal law. Right. They cannot co-opt. But that's a different thing than what you just described.
Right, but that's why I said it would depend on the nature of how they're serving as a sanctuary state or city, what steps they're specifically taking. We use that term, I think, very liberally because states and cities are so proud to say we're a sanctuary city in New York or in Boston or whatever. But what I'm saying is I don't think that they necessarily employ the same tactics as far as what steps they take to serve as a sanctuary city.
So can we agree? It's pretty clear there's a distinction between forcing a state to enforce federal law on the one hand, and people harboring illegal aliens on the other hand. Those are two different things.
Those are
right?
two different things.
And the harboring. Do you know that harboring an illegal alien is punishable by death, by execution?
I didn't know that.
Yeah.
I didn't know that.
Do you have a citation on that?
Well, it's a statute. I could give you the statute.
Yeah, I'll look it up.
I think it's 1813-24. If memory serves me correctly. So the punishment for harboring an alien is a function of what the alien does and whether or not you're doing it for monetary compensation. So if you harbor an alien and you get caught, it's a 5-year sentence. If you're harboring an alien and you're doing it for money, you get 10 years. But if you're harboring an alien and that alien goes off and kills somebody, it's life in prison for you, not the alien, for you, or capital punishment.
Good job on coming up with.
Did I get it right?
I think you may have.
Yeah, I think I did. Right.
Any person who knowing that a person is an alien brings.
Hey, this brain.
This is why we need to get you on SCOTUS. Knowing that a person.
So
is an alien.
You'll see the offenses, and then lower down you'll see what the punishments are, and they're a function of kind of the consequence of having
that violates. In the case of violation of subparagraph A, so it's for financial gain to be fined.
Right, financial gain, 10 years, right? Did I get that right?
Not more than 10 years, correct.
Right, okay, all right.
In case of violation of subparagraph A, be fined
5 years.
Not more than 5 years.
Right,
in the case of violation of subparagraph A,
20 years if they just cause injury, right?
If they cause 20 years. In the case of violation of paragraph A, resulting in the death of any person, be punished by death or imprisoned for any term of years of life.
Nailed it, Joe.
I just wanted to know where it was.
I don't mind you looking it up.
But you couldn't be able to hold anyone from the state.
So imagine if you're harboring an illegal, right? And the illegal goes off and commits a drunk driving homicide. You're subject to execution.
But I think, correct me if I'm wrong, Joe. There's a difference between the sovereign, the state saying we're going to harbor you versus an individual in a state. So maybe you can reach out to the individual, maybe the governor or whatever. Let's say they pass a law. Then I think you'd have to go to court and say, because I know like in New York, they have that they have a particular law that says everyone has a right to everyone has a right to
I don't understand.
To a house or whatever.
Is this supposed to be a criminal statute that the sovereign is applying to the sovereign?
That's what I'm saying. It would essentially be
I
like
don't think that makes sense.
So in your, like when you said they're harboring criminals, New York has a law that says everyone in New York has a right to housing. So they harbor them. They've been giving them $600.
But that's not federal law.
This is but that's harboring, right? Giving them money, giving them housing.
Yeah, you have the state harboring. His point is the state is harboring.
Harboring,
right.
Not an individual.
Right, the state,
so
yes. New York State is guilty of harboring. Yeah, it is.
I don't think that statute would apply to the entire, like that statute.
Are you sure?
I don't think that statute.
I would apply it.
Much as I'd love to, I don't think that statute applies to Mamdani. That's the point.
Yeah.
Are you sure?
Apply to,
I don't see. I can't even imagine.
Maybe not. I don't know. Anyway, I was only interested in the personal.
Right.
Yeah, I think the one-on-one person, yes, but I think when you're talking about the state in general, it'd be harder. Here is the Don Lemon complaint. I found it, pulled it up. The actual complaint from the court, and you can see, and I can tell you this. It's funny because when I saw this,
look how happy Joe is right now. He's like, "Oh my God, I set this up. It was a disaster, and now look how good it is.
It's flowing nice and smooth." So you see this blacked out pure part. This is Don Lemon and his crew.
Right.
You're saying Don Lemon is black? Is that what you're saying?
He's blacked out in this one, unfortunately. But these people, and when you read through the complaint, like it's signed by the judge and everything. But what happened? Just so everybody understands what happened. You'll take this to the judge will read it. The judge says, "I don't believe there's probable cause for those things." So instead of rewriting the whole thing, they just remove the names of the people who they don't want to do. But you know it's Don Lemon because they literally talk about his stream, and what he says and everything. But I will say in this complaint, when you read through it, it's just hard. It's hard to find probable cause for Don Lemon and his crew. It's just very, very hard to find.
Yep.
And I think when you look at this was for instance, people are talking about foreknowledge, because he knew, but then they put these flyers in that they were handing out everywhere. So now you got thousands of people with foreknowledge. Well, if all these people have foreknowledge, did that make them also accessories if they didn't go? So, it's kind of like whoever wrote this complaint wrote it, but in a way that kind of gave Don Lemon cover too, because you knock out a lot of their own arguments. And there's the special agent and the judge. Is it true the judge's wife works?
She works for the deputy AG, I think. Yeah, it's a pretty incestuous relationship with the states.
So if I were Don Lemon's lawyer and I were making arguments on his behalf, this is exactly the argument I would make, and I would consider it a pretty compelling argument. So, is it 100%? Nothing's 100%, but I think he's got a very compelling argument for why he should not be collapsed into these KKK Act violations.
Yeah.
By the way, if I were the prosecutor, of course, I would make very much the other argument.
But I think these people like the Kima Velez, I think everybody, these other three people are stone cold. They got them cold. They have them cold. When you read through this, they're just done.
I don't know how to, maybe, but they seem to fall pretty squarely. If let's face it, if these were all these defendants were black people, but if African Americans, but if they were white people in front of a Planned Parenthood facility, would they not be prosecuted for the same conduct? I mean, we know they would be. So would the journalists.
But this guy is white. The
journalists would be prosecuted.
William
too.
Scott Kelly's white. Yeah.
If I went there, if I went there to try and cover some pro-lifers who were at an abortion clinic, I'd be arrested with them, and the charges would flow against me too.
And that's the problem, right? It's not so much the letter of the law, but we feel like it's being the laws are being
unfairly applied.
Unfairly, right?
Yeah. It's not Joe, it's me. Sonic weapons. So Captain Steve earlier, we didn't understand this thing that he wrote, so he's trying to clarify here. It's not Joe, it's me. Sonic weapons against Minnesota protesters. Venezuela said they felt the effect of sonic sound tools.
I saw that.
So what do you guys think about ICE using sonic weapons in response to the whistles?
You would still have the use of force analysis. It has to be reasonable.
Do you think that's a reasonable force? I'm asking you as a former officer. Do you think
it's another tool that
Nate's making the perfect argument. Of course,
it's a tool that you use, and you got to use it.
How much force is it? Right? Is it force that can readily cause death or permanent, serious physical injury? Then you're using deadly force. You have to have the same justification as if you shot that guy.
Regarding harboring Apply it harder, Branca, harder.
Nate is.
Oh my God, that's my wife. That's my wife right there.
They're like,
okay.
Bro, like, what the hell? Like, what did Alex say? I actually agreed with it. I didn't disagree with that point.
Liz says, Joe, did your neighbors come out en masse to throw you in a trash heap when you use your snowblower at 2 friggin' a.m.? Just worried that you're going to be tarred and feathered. Yes, I was snow blowing yesterday at 2 o'clock in the morning. My neighbors were very understanding. So, but I spent like a half hour out there just because that's when I finished my stream and I didn't have a chance to do it earlier. I have very good neighbors. So you don't want to be my neighbor because I will come out at 2 in the morning. And thank you for your generous super chat. And in fact, so many of you have been very generous.
$50.
Yeah, I haven't really been properly. I haven't really been properly appreciating some of them, several of the very generous super chats that you all have been saying. And I hope you understand that it's because I just didn't want to disrupt this phenomenal flow of conversation between these two esteemed attorneys. So, I normally would spend more time doing that, but I'm sure you all understand that the objective here is to help, continue a healthy flow of conversation.
Yeah, we had a rough go at it at first, but I think now the conversation's flowing, and I think everybody's having a good time. So
yeah, I think we're starting to land our plane soon. I think because we've been here. You guys have been amazing. It's been like over 3.5 hours.
Oh my God,
an hour? It's 3 hours, bro.
We're 3 hours.
My wife is going to be so mad at
me. We know what an hour is the Bronx now.
I'll tell you this, Branca, Andrew, you did well too. You did very well too. This was a very active night for both channels. Yeah. So this is justified. It's not justified. Judge, I rest my case. That was from early. He probably was responding to what happened earlier. The feds recently charged a New Mexico judge and his wife with harboring illegals. Case still in progress. Yeah, I remember that. Yeah, that's pretty wild. These chats are being silly. Sonic is a hedgehog. There you go.
I don't. Oh, that last one, because I don't understand. Like, some of the people there can be justified, while officers are not justified in their use of force. So
this one here,
because that happens all the time. One officer will be justified, and then sometimes another officer will shoot late. I think that happened. I forget what the name of the case, where there was like a pause in the action, and then another officer shot a couple of more times. And then they were like, well, that first volley was justified, but that second use of force wasn't justified. So you could have the situation where it's justified in one instance and not justified in another instance. But I think in this particular case, all the cops, if what happens, which we think happens, the guy's gun misfires and all the cops respond, I think all those cops who shot would be justified based on those facts and circumstances. But I still think the criminal liability would lie with the other officer possibly.
And I think that we covered it. I think you guys, first and foremost, if you can, before we close out here, why don't you share with these people while I add you into the description that I should have done ages ago. Can you share with everyone who you are, what you are, and I'm going to urge you all, if you enjoy this conversation, please, if you can give a like and a follow, both on this channel and on the other channel. You can come over if you're over on Branca's, come over here and give a little like and a follow. If you're on mine, you go over to Branca's, give a like and a follow. Go over to Nate's, like his last video because this guy, he needs more people watching his videos, and but make sure you're following him. And I'm going to tell you I know that we had a rough moment there. Wow,
Joe,
I have a rough moment now. Yeah, but what Nate did earlier was that's reflective of this community that we have, that there's mutual respect and the ability to have conversation and disagreement, which sometimes can get heated, sometimes a little too heated, but that was really impressive what you did earlier, Nate. So I thank you for coming back here and really hitting out of the park since you came back, especially. So, and I thank both of you for coming on here. This was a phenomenal conversation.
Nate, I'll defer to you to close out.
Oh, well, no. First, I want to thank you guys for your kindness. And, again, I just want to, I know I don't have to apologize, but I do apologize for the way I acted earlier. And I'm glad we were able to have a great conversation, because I will say this. I wouldn't have been here 3.5 hours, well, I was here 3 hours because I took a 40-minute break. But I will say this was a fantastic conversation. And I honestly love talking to law. I love talking to law with Joe. I love talking to law with Andrew. So thank you guys. And thank you guys for accepting me back and accepting my apology, because I really, really appreciate it. Thank you, chat, too, because chat, I always say I hate you. I always come and argue with you. But, you know, and this is the first time in the new year that I've come and argued and screamed at the chat. But, you know, and one thing I will always say, too, is that the success of all of our success is due to each other, is due to us being tested, because steel is forged in fire and flames, and you have to have your ideas tested in the strongest possible way if you really are convinced. And I'm one of those people who want their ideas to be tested, because if
that's why you came here.
Rigor, then they I shouldn't be putting them forward. So.
That's why I want you, when you left, I was shocked, because I was like, that's so not the Nate that I know. And that's when you came back. It was impressive, but that surprised me much less, because I know that you like being tested, you like being forged, and you're not hesitant to say, you know what, I was wrong on that one. Like, you convinced me.
Oh yeah, I always say that. Yeah,
all the time.
Yeah.
Right, yeah. And you need to say it more than most. And yeah, I'm just kidding.
No, it's true. I do. I say it all.
Just busting balls. Branca.
I think we have to recognize how enormous it is for a guy to leave angry from a debate and have the moral balls to come back. I mean, that is such a testament to your character, Nate. It's unbelievable. That's super hard to do. We've all of men had this experience, right? We were in a fight. Maybe we even knew we were on the wrong side. It doesn't matter. But to come back, and re-engage as a man.
Yeah.
Honestly, I'm not even suggesting you did anything wrong the first time, but to leave and come back is such a testament to your character. It's tremendous. Man, I've never had more respect for you than I have in this moment.
I really appreciate it. But I came back, well, out of respect for Joe and out of respect for you, because what I did earlier was not right. And
we're good.
And
you much more than made up for it. And I want to tip my cap specifically to Uncivil Law for being so prescient to reach out to Nate so quickly and to help bring this back on board. So thank you, my brother.
I was in bed and I'm like, why is he calling me? He's like,
thank you, Kurt. Thank you, Kurt. It was really cool of you to step up like that. So thank you very much. I want to thank both of you and tell you, my audience, that appreciate the crazy level of engagement we have with you. I hope you all enjoy this. Again, please make sure drop a comment. Let us know if you think I should check the poll, because I did put a poll up who won here, so I should check before I leave.
What was that, like 2 hours ago? That
was like, it's been sitting out there for a long time.
I'm gonna lose. So.
We both won.
I know. I think I put it up after you came back.
What's the measure of success? The measure of success is you made a reasoned legal argument, right? That's what we do for our clients.
Yeah, there's actually, to be honest with you, no one really knows how it's going to play out. But you make an argument to say, I believe this is justified. It's not just, and then here are my reasons, and then people take it with what they will.
Right. Right, and 76% agree with Branca. So there you go.
All right.
Sorry, Nate.
No.
All right.
But you know what? It's funny because when I go to Pisco, it's the exact opposite. So.
Well, no, yeah. Well, they're the.
I have a lot of haters.
All right. Well, I thank you all for joining me. God willing, I'll be back here tomorrow evening at 10 o'clock. Please make sure you remember, stay away from lab meat. It was never meant for you. It's meant for they, them, not you. And do not eat the bug.
Good night, guys. Hey, great seeing you, Nate.
Good night and Godspeed.